can be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Good afternoon. Good afternoon. Today is Wednesday, March 12th, 2025, and Karen Reed was still framed. You too can get one of these mugs on Microdots merch shop. For those, shout out to Microdots. How's everybody doing today? There's a couple of motions that we didn't get to yesterday, and I think they kind of deserve their own show. Yesterday was a marathon. We were here for hours and hours and hours. And then there's a couple of motions that we didn't get to. And I didn't want to squeeze them in because, they deserve their own time, I think. One is the motion about the defense wants the jury to be able to know that the ARCCA witnesses were hired by the feds because it seems that the jury was very confused about who hired ARCCA during the first trial. And we know that because of the jurors that have come out and spoken to certain reporters and to certain news entities. And it may have worked against the defense because some of the jurors thought that either ARCCA was hired by Karen Reed's defense team and or Turtle Boy, aka Aiden Carney, and or, not the defense team, Karen Reed's car insurance company. And so the defense has made a motion to allow that information and that they were hired by the federal government. That's one motion. Another motion that we didn't get to is the motion about the defense wanting to be able to state the grounds for their objection so that it preserves the appellate record. And what's really confusing is that in the court docket, the way that it was entered into the court docket, they said that it is the Commonwealth's motion, or is that 595? The way that it was entered into the system, they must have changed it because yesterday it said Commonwealth's motion to allow counsel to state grounds for objections. And so that's what I thought yesterday when I was reading it to you. And I'm like, that's kind of weird. Why would the Commonwealth want that? Because remember, Lally needed all the help he could get. Mr. Lally, do you want to object? Mr. Lally, do you want to object? And a lot of times we saw witnesses sort of looking over, waiting for objections. Mr. Lally, do you want to object? And so the record, actually, the docket has now been changed to say that it's defense motion. So it is a defense motion. We have that. And then what I thought was interesting. Oh, you did? Look at Matt's dad. I wasn't crazy, right? I wasn't crazy. Thank you. Thank you. I'm like, wait a second. It got changed. Was I crazy? Matt's dad emailed Jim, the court clerk, to tell him that he had it wrong. Matt's dad is here to help us with all the corrections we need here on a daily basis here in the upside down world of Massachusetts, Norfolk County. We're here for it. But, according to Kevin Reddington, I am credible and not salacious, and I am an excellent source of information for the YouTube. So I got that going for me. We looked at that yesterday. And then this other motion, well, there's the motion about Proctor and his false and irrelevant statements to be excluded. But what a lot of you might not know, who may be new to this case, is that Sergeant Lank, the friendly, first on scene, first allowed in the house anyway, has been the fixer. He's like the Ray Donovan of the Albert family, going back 20 years. And during the first trial, a lot of evidence was allowed to be brought out, some evidence anyway, about a lawsuit that happened some 20 years ago involving the Lopalito brothers, right? The Lopalito brothers. So I thought it might be fun to go back and talk about the voir dire that they did with Lank all the way back. It was day 5 of trial. Many of us may not remember back that far, but it was May 6th of 2024. And the judge required Sergeant Lank to come in and have a voir dire outside the presence of the jury and talk about this incident that happened all these years ago. And a lot of you might not even know about that incident. And so I thought it would be interesting for those of you who don't know to see like the shenanigans, tomfoolery, and ballyhoo that has been going on for decades with these people. For decades, right? Yeah, the Commonwealth does not want their witnesses impeached. They want everyone to just believe what they say. And we don't believe what they say because we know better, because we have the proof. We have the receipts, and we do our due diligence, and we've read all the police reports, and we've seen how many conflicting statements the witnesses have given, and that in none of the initial reports from any witness did anybody in any of their written reports say that they heard Karen Reed say, "I hit him." Not once, not twice, not 3 times, and not 4 times, like Lally said in his closing. I did it. I hit him. I hit him. I hit him. I hit him. We don't take people at face value, Becky B. We don't trust anybody. Look, trust is something that needs to be earned. And once you break the trust, getting back in that circle of trust isn't going to be so easy. It is not going to be so easy, right? Thank you very much, Olivia, because Melanie is extremely credible. All right, Reddington? He's like, there's this new thing called the YouTube, and there's people that talk about the cases, and therefore I think Dr. Turk should have a change of venue. And then he talked about me, and my name is on the Chiron, and we looked at it yesterday. That's in the Turk case. It's in the same building. The judge is not impressed. And he said, no change of venue for you, Dr. Turk. And rest in peace, Katie McLean. All right. So what should we do is there any other motions that we didn't go over that you want to do? And who knows what other droppings could happen while we're sitting here. We just never know. We just never know what's going to happen, because every day is a new day in Norfolk County. All right, let's do the objections first. That's 593, 594. I think. No, 595 and 596. If I have those pulled up, do I? Maybe not. Let's do ARCCA first, since it's up on the screen. Because I don't think we need to read it word for word. I think we can just get the gist of it. Because really, isn't this all about the defendant getting a fair trial under, our Constitution of the United States of America? As such, the United States of America does not have the Iraq as such, the maps. Anybody know who I'm imitating? I think you do. We went through a lot yesterday. I think most of them are going to be argued. They're going to be argued. So next week, here's the schedule for next week. For all of you that may call into work sick on Tuesday with the Irish flu, say no more. Say no more. I can say that because I'm Irish. All day Tuesday and the 18th and Wednesday, the 19th, is set aside for argument on these motions in lemonade, as the closed captions once so comically called them, and we have adopted that. These are really called motions in limine, which are made prior to trial in order to either get rulings on evidence that a party wants to have excluded from the trial or included at the trial. It can work both ways. Both ways there. All right, so I think what we can read first here is the affidavit of counsel in support of defendant's motion in lemonade to allow evidence of lack of bias. And this is the ARCCA motion. Nothing yet, but you know what happens. Somebody says, is there anything new today? There's one thing that was docketed. It's the affidavit of counsel in support of the to prohibit Michael Morrissey and MSP from having juror contact. And I think we went over the motion yesterday, but we just did not go over the affidavit, which is just in support of the motion. I don't know if it's scanned in. A lot of times things get put into the docket right before, right at the close of business, COB, right around 5 o'clock. So, we're here. Yeah. Lemonade is just Latin for, oh, one more thing. Oh, but wait, there's more. Thank you, Trevor Bobever. I think Betterow mentioned D&E Pizza. What do you mean in his latest Betterow letter? Yeah, maybe. If we have time, let's see how far we got. But Betterow did drop another letter. That's pretty awesome. And, there's that. Yes, thank you, Kelly O'Brien. Thank you. Thank you, Kelly O'Brien. You going to call in with the Irish flu next Tuesday? Are you? Mm-hmm. Say no more. I won't tell. It's just between us. You're in the circle of trust. All right. Here is David Yannetti's, I think it's David Yannetti's affidavit of counsel in support of defendant's motion in lemonade, to allow evidence of lack of bias. And this is docket number 594. I'm an attorney licensed to practice in Massachusetts since December 20th, 1989. My office is this. On January 29th of 2022, I was retained to represent Karen Reed regarding the above captioned matter. I would just also like to point out, not only was he hired the same day that John O'Keefe's body was found, the same day of his murder, but it's also the same day that Boston 10, I was at WBZ, and other news outlets started reporting, or did they start reporting that on the day she was arrested? Investigators say they have ring camera footage of the incident of Karen Reed hitting John O'Keefe with her car. I'm going to ask that unless anybody is sending me any documents that are dropping, to please refrain from emailing me during the show, because it is so distracting, and because they pop up on my phone and I can't, could you save your emails for later? Just maybe even you could send them on a delay or something. That'd be great, because I can't stop what I'm doing to read them, and I can't just, abandon my plan to address whatever it is that you're emailing me. I love you all so very much. I really do. I love you with all my heart. All right. So this is his affidavit. Here we go. Whoop. 2 witnesses from ARCCA testified during the defense case during the first trial in this matter, Dr. Daniel Wolf and Andrew Rentschler, PhD. They both have PhDs. They are both biomechanical engineers. They are both wicked smart. They built a cannon. It was awesome. And we have dubbed them the Crash Daddies. The defense did not initially retain or involve those experts in this investigation. They were instead retained by the U.S. Attorney's Office for the District of Massachusetts as part of their probe into the investigation of the death of Officer John O'Keefe. Each of these expert witnesses performed their testing and analysis pursuant to the mandates and at the request of the U.S. Attorney's Office. The defense had no input into what manner of testing or analysis they would be performing, nor what materials they were allowed to consider. Prior to the first trial in this matter, as discussed at length during hearings on February 18th, February 25th, and March 5th of 2025, the defense did not pay ARCCA prior to their testimony. At the first trial of this matter, the defense was prohibited from mentioning the federal investigation into this matter at all. Consequently, the jury was not allowed to consider that the ARCCA experts were not retained by the defense, were not instructed by the defense to perform testing, were not provided by the defense any material to consider, and were not involved with the defense at all prior to the completion of their testing. And I just want to tell you, as a civil litigator over 30 years who dealt with many, many experts per week and month, this never happens. This never happens. You never get the benefit of an expert who totally agrees with your theory of the case that was not hired by yourself or the other side. It never happens. So this is like a first time for everything kind of thing. And I don't think that there are any cases on point. And so that's why this is a very interesting topic. Argument. This just doesn't happen. Where am I? The inability of the defense to explain the origins of ARCCA's involvement in this case led to juror confusion and prejudiced Ms. Reed. After the trial, jurors have come forward to express their confusion about ARCCA's testimony. At least one surmised that ARCCA must have been retained by Ms. Reed's car insurance company, which would lead to an inference of bias in favor of Ms. Reed's version of events. At least another postulated that the ARCCA experts were fame seekers. Having heard about this high-profile case, they wanted to insert themselves into the trial to gain positive publicity for themselves and ARCCA. It is ironic and wrong, in retrospect, in my view, that this court was seeking to have the jury avoid speculating about a federal investigation, but in so doing, caused the jury to speculate about ARCCA in a way that tended to diminish their credibility and therefore diminish their effectiveness for Ms. Reed. Probing the bias or lack of bias of a witness, including an expert witness, is a constitutional right possessed by every criminal defendant. Robbing the jury of the truth of the origin of ARCCA's involvement in this case robbed the jury the appropriate opportunity to give appropriate weight to the opinions of the ARCCA experts. The testimony of these witnesses, based on their analysis and findings, corroborates the essence of Ms. Reed's defense. Okay, and here it is. This is the essence of Ms. Reed's defense. And I have been screaming about this forever and ever and ever. Officer O'Keefe's injuries are not consistent with being hit by her SUV, nor is the damage to Ms. Reed's SUV consistent with colliding with a pedestrian. That is, and I'm breaking it from the document to say, it has been my opinion from the beginning that is the only thing that the jury needs to decide in this case. Was John O'Keefe hit by a car? Yes or no? If the answer is no, not guilty, we all go home. Right? And now we have the benefit, after the trial having happened and after all of these jurors coming forward and speaking to press and Vanity Fair, and Aidan Carney was the first one to get a real live juror on his show, Ronnie, who, when he went on national television, wore a pink shirt and pink bow tie, wore a different bow tie every day of the trial. Now we know what the jury was thinking, what they thought about the architect's testimony. And so they just sort of disregarded it because they said, well, obviously they were hired by her insurance company or something. So, they don't want to pay the claim on the car accident case. So of course, how can we believe what they're saying? And it is important to note, and I know that many of you in the chat are claims adjusters for insurance companies, either bodily injury adjusters, property damage adjusters. I know because you've written to me. There is no motor vehicle crash report with regard to this case. This is a pedestrian fatality, according to the Commonwealth. Not only is it a pedestrian fatality, it is a dead Boston police officer, brother in blue. How was there never a crash report completed and filed with the registry of, I think you guys call it the RMV, the Registry of Motor Vehicles? We call it the DMV. In New York, it is the law. It is the law. And if you don't call the police at the scene of the accident because, maybe there's minor damage and, injuries, and you just want to get on with your day, if there's no official police report, but even if there is, you are required as the driver to file a motor vehicle accident report within 30 days if there's over a certain amount of damage, property damage, or injuries. And so the fact that the MSP, who apparently handle all fatalities, did not fill out a motor vehicle accident crash report, even though they decided, or Proctor did anyway, within 16 hours, that's what happened here. A motor vehicle accident fatality, that they didn't fill out that report. I don't know if they can bring that up at the next trial, but I think they should. Because, if you didn't document it, it didn't happen. Here's the other thing in New York, okay? In New York, and I'm not sure exactly what the law is in Massachusetts, but in New York, we're a no-fault state, which means that if you are a pedestrian hit by a motor vehicle, the vehicle who hits you, their car insurance pays all of your medical bills up to a certain amount, or until the IME doctor says you don't need any more treatment. And so in a pedestrian fatality, all of the billing from the hospital, the ambulance, all of that stuff in New York anyway, would have gone through Karen's auto insurance as the carrier. They also have a death benefit where they pay a certain amount of money towards funeral expenses. Same in Massachusetts, no fault. So is it the same, Marie, that if a pedestrian gets hit by a car, the driver's auto insurance pays the medical bills? Okay. Did that happen here? No, I don't think so. And I've said for so long that without a motor vehicle accident report, how are they going to succeed in the civil case? I don't know. It's going to be a problem. It's going to be, I saw somebody fly by. Mickey, you sent me an email. I just said that I have 4,000 emails. I'm just telling everyone, please do not email me while I'm on the air because it's really distracting. Also, 700 of you have sent me the video on YouTube of the guy who bought the taillight and smashed it with a hammer. Seen it. Boozy Beauty's videos. I subscribe to her. I get notifications. I've seen them all. Everything that you have sent me, for the most part, trust me when I tell you, I am on top of nothing. Like I am on top of this case. Although someone did send me something interesting yesterday, some emails from David Traub that I had never seen before, that if you remind me later, I will read, because what he said about that hostage video to someone was very interesting, I found. Yes. Okay. So Lisa is a medical coder, and we'd have to put a code saying it was a motor vehicle accident versus pedestrian, as well as bill the auto insurance, or it would be insurance fraud here in Massachusetts. Well, there you go. There you go. So, I mean, that is just one of the big problems in my mind in this case. If you were so sure that John O'Keefe was killed by a car, why did none of you fill out a crash report? Wild, right? David Traub was the spokesperson for the Norfolk County DA's office. He has since jumped ship. He's the one who is emailing about Jennifer Coffendorfer, whose name I do not allow mention on this show, except I'm going to mention it right now, who said, let's reach out to her. She's the one I told you about with the huge Twitter reach. He's the one. Right. Scott McGinnis says there was no accident report because that was not their original plan, to blame Karen Reed for running Officer John O'Keefe down. Right. But you know what, Scott, they could have filed it within 30 days. They had plenty of time to file it. Might not have been their original plan, but it was their plan by the day that she was arraigned, right? Which was only like 3 days later. I mean, there's plenty of time for it. They could have. Oh, thanks, Andy. Thanks, Andy. I love you too. Right? Kindergarten cop says it was DV. That's the way it was called in, as a domestic. Yuri Buchanan testified to that. No, Olivia. I have an email from Traub. Should we look at it now? Let me just finish this and then I'll go right to it, because Olivia, stay here because you may want to run with this. So just don't go anywhere. Okay, let me just finish this before, because you know I'm like ADHD. I lose my train of thought. Robbing the jury of the truth of the origin of ARCCA's involvement in this case robbed the jury the appropriate opportunity to give appropriate weight to the opinions of the ARCCA experts. The testimony of these witnesses, based on their analysis and findings, corroborates the essence of Ms. Reed's defense. Officer O'Keefe's injuries are not consistent with being hit by her SUV, nor is the damage to Ms. Reed's SUV consistent with colliding with a pedestrian. Allowing these witnesses to explain that they were initially retained by the DOJ and not by the defense, an insurance company, or a rogue third party, aka Aiden Carney Turtle Boy, provides important context for their testimony. The Commonwealth is, of course, free to explore their allegations of bias during cross-examination. Not stating who retained ARCCA experts to conduct their testing, however, keeps important context from jurors and causes confusion. The defense is not seeking to mention the existence of a federal investigation when questioning these witnesses or during any other part of the upcoming retrial. So they don't want to say that, there was a federal investigation so much, but they want to make it clear who hired them. Accordingly, I believe it's in the best interest of justice that the Honorable Court allows this motion in lemonade. XOXO. Misty Yannetti. Thank you, Team Brittany, for the gentle reminder. That was 594. 594. All right, let's go to these emails because, curiosity killed the cat and all. So David Traub was the spokesperson for the Norfolk County DA's office. He was their mouthpiece. When did he leave, you guys? It was kind of recently, right? It's kind of recently. Where did these emails come from? A viewer sent them to me. Hang on. Oh, I'll give her credit. Sweet Caroline. Sweet Caroline. Ba, ba, ba. Good times never seem so good. So good, so good, so good. All right, let's see. Okay, so you may recall. Oh, this is 61 pages of emails. What? Oh, this is interesting. Olivia, I might have to send you all 61 pages of this, but the one that stuck out to me the most is this one. Who's Brandon Hunt from Norfolk County? Anybody know who's Brandon Hunt? All right, here we go. So this was around Friday, August 23rd, 25th. That's when he released that hostage video that a lot of people are just discovering for the first time, that we've been over many, many, many times on this channel. The hostage video where Michael Morrissey says, Colin Albert is innocent. He didn't do anything wrong. Nothing to see here. Michael Proctor never went in the house. Nothing to see here. Well, here's an email from David Traub, who was the Norfolk mouthpiece, right? Friday, August 25th, 2025, to somebody at iCloud.com and somebody at gmail.com with a CC to Helena Rafferty. And it is forwarding a statement on Commonwealth versus Karen Reed. And it says, August 23rd transcript of Morrissey's remarks for your convenience. Good afternoon. Chief Rafferty communicated your note of concern to us while we were actively filming the very statement that you were suggesting. I've called this a hostage video since the beginning because I said it looked to me like he was reading a script. Somebody was on camera holding a gun to his head. And what the duck is this? Please be advised that this statement was also sent to Dateline at NBC, Nightline, and numerous other interested parties not visible in the distribution list below. David. Next email said, and this is who they sent it out to. A couple of redactions at Comcast.net, and there's the Canton Citizen in there, CourtTV, Gretchen Voss. Good afternoon. A video statement relative to the ongoing harassment of witnesses in the murder prosecution of Commonwealth v. Karen Reed can be downloaded here. Please be advised to download this to your own system for retention, as it will only be available for download for a small number of days. Well, so what's that? A self-destructive statement? Self-destructive. So they sort of gave them a link that was going to expire and self-destruct unless they downloaded it within a couple of days. Okay. For your convenience, a transcript of the district attorney's statement is attached. Thank you for your attention. David Traub, President, Press Officer / Director of Communications, Office of Norfolk County. And that's not the exact email that I wanted to show you. So just hang on for 1 second because I pulled up the wrong one. But that is a good one because that's who they sent it to. Everybody at CourtTV. Okay. And so in response to that email came this email. We're like, okay, who suggested it? Who suggested it? Who suggested it? Julie, Julie redacted, wrote this email to David Traub regarding the statement on the Commonwealth, which they spelled, look, Commonwealth v. Karen Reed. Yes, I see it now. I've not read it yet. I appreciate your quick replies. Julie. I don't know which Julie it is. I don't think it's Julie Grant. Let's see. Who did Michael Morrissey talk about during his statement? Well, talked about Michael Proctor. Talked about Colin Albert. What's Colin Albert's mother's name? Julie. I don't know if it's her. I'm leaving this up to you guys. You guys are the armchair detectives. But he said, Julie, you're the one who suggested it. And we were in the middle of taping the exact thing that you suggested. I don't know if it's her. Can't confirm. Not clear from your response that you saw that the link was included with what I sent you. Best, David. Here's another from Julie, 5:28 on a Friday to David Traub. Okay, thank you very much for getting back to me, Julie Blank. And then that was in response to, good afternoon, Chief Rafferty communicated your note of concern to us while we were actively filming the very statement you were suggesting. Please be advised that this statement was also sent to Dateline at NBC, Nightline, and numerous other interested parties not visible in the distribution list below, David. Somebody tell me, because I'm not, up on my local Canton politics, but in August of 2023, was Chris Albert, Julie Albert's husband, already on the Canton Select Board? I don't know. Oh, okay. Thank you. So David Traub resigned. Somebody just put it in here. Ding, 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 ding. This is Christopher's opinion. 100% Colin's mom. He put a video out vouching for her son. Somebody told me when David Traub, Nancy says so, Helena was actively working with Traub. You guys can connect the dots. iPhone, sent from an iPhone. That's right. As if the feds don't have enough. He was the selectman. He was already a selectman in August of 2023. So essentially he was like, I don't know, he was Helena Rafferty's boss, right? Why are the names redacted? That's the way they came out. I think this was a FOIA request. There's like 61 pages of these emails here. Thanks to Sweet Caroline. Iceman says, no doubt it's Julie Albert, in my opinion, after that email stating their concern. So there you go. Chris got on in April of 2024. Hi, Olivia. So, Olivia, did you have this information already? Did you know about this? Has this already been talked about? It was new to me, so I thought it was interesting because I always thought this was like a hostage video. Wait, hold on. Where's Olivia? Don't know if you saw my message before, but David Traub submitted his resignation right after Farwell was indicted. Wow, that's interesting. You guys are already on it. Stranded in Duluth, it says, based on the length of the redaction line, the name has 6 letters. Well, something to ponder. And it was a self-destructing download. Better download it quick before we delete it. The plot thickens. I don't know. I'm just the lawyer. What do I know? What do I know? But I'm sure if somebody went through these 61 pages of emails, I don't have the time to do it, but I'm sure there might be some other interesting stuff in there if nobody's done it yet. I don't know. Just tossing that out there like a little Easter egg. Happy Easter, everyone. So there's that. See, there's nothing I like better than I told you so. I told you so. I told you it was a hostage video. I told you that somebody was forcing him to write that. I told you it was being suggested by someone. Look the other way, everyone. Look the other way. I don't know what Julie it was. Mike B from the 413 says it could be Julie Nagel, given I think it's close in the to the time that Turtle Boy had reported about Julie Nagel Venmo for Bev's Cape Cod house rental. Could be a lot of people named Julie, but somebody had some very grave concerns about what was happening, and such grave concerns that they would have a direct line to David Traub. Do you think that Julie Nagel would have a direct line to David Traub? Look, I don't know. I'm not the solver. I'm just the Easter Bunny. Thanks, Mike B from the 413 for your super chat. Cynthia says he resigned October of 2024 after 25 years. David Traub did, and I think he got a job working for some white shoe law firm, right? Thanks, Cynthia, for your super chat. Chloe Alvarez Raven says it was definitely a hostage video. He looked like those last 2 girls when they said they were happy living with R. Kelly. Thank you. Hey, D&E Pizza Duck says he left October of 2024. Thank you. The Goodmans are here. They've gifted a membership. Thank you. Commander Ed says no accident report and no manner of death, yet Karen is charged with murder 2 and OUI and the lesser included. How? Because we're in the Matrix, the Upside Down, Narnia, the Inside Out, the Twilight Zone. We have emojis for that, members. Show everyone some emojis. Show everyone some Twilight Zone emojis. The amount of emojis that we made for this trial are crazy. Make everyone jealous that you're a member and they're not. Show them the solo cup. Show them the puffy jacket, the leaf blower. Smooth as butter for Alan Jackson. The sigh emoji for every time the heavy breathing happened in the mic, the we are outraged, the handcuffs, the fan, the what if any, the wait for us. And I have now allowed the boss baby emoji to be used for Hanky Spanky Brennan, even though we used it originally. We invented that for the Telus trial in Vegas, but I'll allow it. You know why, Commander Ed? Because they wanted to pin it on the girl. They had to pin it on the girl. Live, laugh, toasted about says correct. Even while investigated, insurance will pay out legal for her and benefits for the victim in most cases. Thank you for your super chat. Shannon says, did Bev have to decide the motion to dismiss prior to next week's arguments? Is there a time frame? Well, what we know is in the last persecution of Karen Reed, took her many, 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 many months to decide certain motions for the defense. Prosecution ones were usually timely decided, but there was one motion that was out for like how many months? I forget. I want to say 7, but I don't think it was totally 7. You would think if she wants the trial to go ahead on April 1st that she's going to definitely decide, right? Quickly, soon, hopefully. She still also has not decided on whether or not she's going to allow the ARCCA witnesses to testify, because that motion is still hanging out there. And that's the motion during which Hank Brennan got up and gave his thoughts about, the ethical violations of Alan Jackson. So we're still waiting on that. Who knows when that's coming? So, is there a statutory time frame in which she's supposed to decide? I don't think there's any real hard and fast rule that she has to decide by, but you would think that if she really wants this to happen on April 1st, she would. But then again, who knows? Thank you, Shannon. Julie is here. She said it was me. Or how about the Shaggy defense? It was me. Tracy gifted 5 memberships. Thank you, Tracy Walker. I appreciate you. Chief LOL Rafferty says, no crash reporting. Karen's insurance company hiring ARCCA. Okay, got it. Yeah. Yeah. Is the absence of evidence evidence? Thanks, Faye. Cheers to your credibility, intelligence, and fairness on the YouTubes. Right, and not salacious. Thank you so much. I have a glowing recommendation from Kevin Reddington. Auntie Bev's wine shakes. This case just keeps getting crazier. Yeah, you couldn't even script it. Andy became a member. Welcome, Andy. Attorney Wannabe says, whatever happened to the motion to measure and reenact the scene in John's driveway and Karen backing into John's car? It was agreed between the parties that whatever measurements had already been taken had been provided to the defense, and therefore they did not need access to the driveway. But they still do have an expert that is going to come in, hopefully, and testify about that. They have 12 experts because, remember, Mr. Brennan said that's why he needed the weekend to file his motions in Lemonade, because he was just provided with 12 experts. And so he needed the weekend. Sweet Caroline is here. Thank you for your 20. Says, I started going over the Google Drive Sleuthy put up a long time ago. These emails were not labeled as such. They've kept me up for days now. She can't sleep. Sweet Caroline is up 24/7. Thank you so much. I didn't realize there were 61 pages of them, because when you sent it to me, I originally just pulled up that one page and I'm like, Julie, why is Julie suggesting that they do a video? Then when I just pulled it up now, I pulled up the wrong attachment. It's 61 pages. I'm like, wow, that's a lot. Absence of evidence is not evidence of absence, says Venus Blue. Thank you. And Alessi's Google search not says, now it is pinned on Proctor. Yes, it is. Yes, maybe we can do better. Rose letter. Thank you. Thank you, Dr. Russell's the goat. I'll keep that here. Did I just see that Lally's face has no value? It's insufficient on its face. Thank you, Scout November Light, for your super chat. I appreciate that. And on top for being on top of the super sticker. And Vixie says, let's go. Twilight Zone 913. Hi, everyone. Just sitting back watching the show. Went to Stoughton High with all of these corrupted cops. The Farwells, Buchanan. Actually really liked Yuri in school. So sad to see this happening. Oh, Twilight Zone 913. Thank you for your super chat. That would be interesting to find out about what Yuri was like in high school. And Rehome Sallyport Camera says, I think she's waiting for us to forget. Sneaky Bev. I don't know. I don't know what she's waiting for. Let's look at, where's 593? 593. So this is the motion that goes with the affidavit for the ARCCA. And the reason it is hard to find is that it is called Defendant's Motion in Limine to allow evidence of lack of bias. But it has to do with the ARCCA witnesses. So there's that. And this one is 16 pages, so we're just going to go over the salient points. Hang on one sec. Okay. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to allow, during her retrial, reference to the fact that it was the U.S. Attorney's Office that initially hired employees of ARCCA, namely Daniel Wolf and Andrew Rentschler, PhD and PhD, and not the defense, who commissioned these witnesses to perform testing and analysis of evidence related to this matter. See affidavit of counsel in support of the motion, which we've already read. So now we're just going to look at a little bit of the legal argument. As grounds, therefore, Ms. Reed states that their retention by the U.S. Attorney's Office and not by the defense bears directly on their credibility, rebuts any contention by the Commonwealth of bias, will avoid causing the jury to unfairly speculate about the origins of their involvement or otherwise prejudice Ms. Reed's constitutional right to due process and a fair trial, citing the amendments to the Constitution 6 and 14 and the Massachusetts Declaration of Rights, Article 12. And footnote 1 says, Ms. Reed wishes to clarify herein, in light of information sought by the court during recent motion hearings and disclosed by the defense as reciprocal discovery, that the defense was invoiced by and did pay ARCCA only following the conclusion of the first trial. I'll break just to say, despite the court's grave concerns, that's what the grave concerns were about. The defense intends to comply with its reciprocal discovery obligations pursuant to Massachusetts Rule 14 regarding ARCCA's participation in the retrial, including its continuing duty to disclose under Massachusetts Rule 14 should it acquire any additional discoverable information following the March 6 reciprocal discovery deadline. And here is the factual background. And for those of you who did not watch the first trial, you may be new to the case, or you want to go back and refresh your recollection. They tell us that on day 31 of Ms. Reed's first trial, June 24th, 24, both Daniel Wolf and Andrew Rentschler testified. It's easy if you Google Karen Reed trial day 31, you'll get all the videos from day 31. No, I did not just read this. I read the affidavit. This is the motion where I'm going backwards. Don't worry, Alessi's binder. I know you better than Breenan's binder, but I had a reason for going backwards because he said everything important in his affidavit, and we're going to pick through this. We're going to pick through it. In fact, these two employees of ARCCA explicitly articulated that they did not have contact with the defense or the Commonwealth regarding the specifics of their testing, did not consult with the defense or the Commonwealth, and Dr. Wolf himself clearly noted that ARCCA employees were hired by another agency not connected in any way to the defense. The particular agency was left for the jury to speculate about, and at least one member did. And they're attaching an affidavit, which I believe has been sealed. I think. They're not talking about Yannetti's affidavit, are they? Moving on. The independence of these ARCCA employees, specifically Wolf and Rentschler, was reaffirmed during motion hearings ahead of Ms. Reed's second trial, footnote 2. See the transcript. Okay. Nevertheless, these individuals who will serve as two of Ms. Reed's most critical exculpatory witnesses were indisputably engaged and hired by the U.S. Attorney's Office to conduct their independent review, analysis, and testing surrounding the singular question of whether Mr. John O'Keefe died as a result of an auto pedestrian collision with Ms. Reed's SUV. That is the only reason they were hired, to determine whether or not John O'Keefe died as the result of being struck by Karen Reed's Lexus. They were not hired to find out if that's not what happened, what really did happen. That's all they were hired to decide, or to determine, or to investigate, test. These highly qualified experts have determined to a reasonable degree of scientific certainty that one, this is the important part, so if your mind is wandering, listen up. These highly qualified experts have determined to a reasonable degree of scientific certainty that, number one, Mr. O'Keefe's injuries and death did not result from being struck by Ms. Reed's SUV. And number two, the damage to Ms. Reed's SUV did not result from colliding with O'Keefe. Period, full stop. Those are my words. But I remember somebody said that once during pretrial, and I made it the title of my thumbnail. Period, full stop. I was one of the defense attorneys. In other words, the scientific data establishes that Ms. Reed did not strike Mr. O'Keefe with her vehicle, Both Dr. Wolf and Dr. Rentschler, two individuals who were not hired by the defense to perform their testing, testified to this highly relevant and exculpatory fact during Ms. Reed's first trial and during voir dire under oath and the threat of perjury. So how the hell can the Commonwealth prosecute? Well, Serenity, I'm glad you asked, because all of this information was dropped by the feds prior to the first trial on both sides, the Commonwealth and the defense, because the then acting U.S. Attorney for the District of Massachusetts, Josh Levy, said in a conference call with both attorneys, I cannot in good faith allow this case to go to trial. So here's all of this information. They call it the TOUHEY information, TOUHEY. And that is a case. It's like a procedure that you must go through to request materials from the feds regarding a federal investigation that is not involving, that they're not a party to. Okay. So those are the TOUHEY documents. All of this stuff was given to the defense and the prosecution. I think it was on a Friday. I don't remember, but I remember that they came back to court maybe after a weekend and the judge was questioning them about it. And the defense said, we haven't really had time. There's 3,074 pages. I still remember the exact number. So we're not sure what's in there. But we imagine that there has to be exculpatory information in it because in a conference call with both of us, both counsel, both sides, Josh Levy said, I can't in good conscience allow this case to go to trial. And so one of the only times we have ever heard ADA Laura McLaughlin get up in court and say anything was that day. And she got up in front of God and everyone and all the worldwide audience and said, Your Honor, I've been through everything. And like 90% of it is in line with the Commonwealth's theory. I'm sorry, what? First of all, girl, you had time to go through 3,074 pages. This was not only included the ARCCA crash report that says John O'Keefe was not hit by a car, which is clearly exculpatory. Proctor's text messages showing his bias against the defendant. And I don't know, name some other things that came out in those 3,074 pages. And then Levy left. But you know what? It's not uncommon. Change of administration. It happens all the time. Leah Foley is the new person. We don't know if it's over. I don't want to get into the weeds on whether the federal investigation is over. I just want to talk about what already happened for now. So there's that. Okay. So why are we here? How did we get here? It's a Talking Heads song. It's on the playlist. The playlist is linked below. I am sure, probably, maybe, I think, that Josh Levy thought, okay, once I release all of this information with these two highly qualified biomechanical engineers, and also there was a report from the feds that the 227 search happened, right? They had that too. They had those messages, those group messages between Alberts and McCabe's about tell him the guy never went in the house. We'll find out more tomorrow. Don't want to text about it. And then tomorrow, Jennifer McCabe goes to Lank's house and makes up a whole story about it. I mean, so much stuff was exculpatory. So I think Josh Levy thought, all right, well, Morrissey's going to have to drop the charges. I mean, the evidence is overwhelming that something else happened. He wasn't hit by a car. And they didn't. And we watched 10 weeks of trial. We watched a lot of nonsense come into evidence, like the Aruba sisters, like inverted videos, like people changing their testimony on the stand. I hit him all of a sudden, was never in any report. All of a sudden at trial, it's I hit him. It's insane. So the answer is, I don't know how we got here. I guess the only way out is through. So we just got to keep going. Furthermore, the Commonwealth, by its own admission, has admitted that it's not the ARCCA witnesses that I have the issue with. He said that on February 18th, though. Yes, he did. Moreover, the Commonwealth stated that it doesn't care if the ARCCA witnesses testify at trial. I don't care about their opinions. I'd welcome ARCCA. He said that day too. We were there for it. Most recently, the Commonwealth communicated to this honorable court on February 25th of 2025 that there is a murky relationship between the defense and the U.S. Attorney's Office relative to these ARCCA witnesses. And there's a very unclear relationship as we stand here right now between the history of the interaction between the defense and the ARCCA witnesses. And that's in the transcript from February 25th. You were here because I was yelling probably at the TV and you. The Commonwealth has additionally conceded that we still don't know the relationship between the defense and ARCCA. We don't know about the impact it has on the first trial. The Commonwealth has provided no objection or legitimate legal basis for not disclosing in Ms. Reed's second trial that employees of ARCCA were hired by the U.S. Attorney's Office. In fact, the Commonwealth itself has articulated that there is a lack of clarity about key information pertaining to these potential witnesses. If the Commonwealth, who has been privy to the relevant discovery for months and has had an opportunity to question these witnesses during voir dire and Ms. Reed's first trial, and by the way, it's not our fault that Lally did a crappy job. I'm just adding in their words as my words, but has expressed confusion about the nature of the relationship between ARCCA and the defense, then it is only logical that the jury too might be confused by the nature of ARCCA's involvement without a full and complete understanding of how, why, and by whom these individuals were hired. There you go. I'm not yelling at you. I'm yelling with you. Sometimes it feels like Ms. Melanie's yelling at the whole class. It's Team Wicked Smart. Be this pure. No, I'm yelling with you because people say when you're yelling, you're saying exactly what I'm thinking. I mean, look, you can go watch a neutral channel if you want. I mean, you can. I fully admit I am not a neutral channel, and I am not going to sit here while this woman is railroaded for a second time. Is over $5 million in debt, had to sell her house, liquidate her 401ks, and is now living with her parent. I'm not going to stand by and sit on a fence, because you know what happens when you sit on a fence? You get splinters. You know who's got time for that? Nobody. But there are neutral channels out there that you can go watch about this stuff if you want to. I'm yelling with you and for you, not at you. There's a difference. And I know that's not what you meant because you were just joking because you guys are funny because you're the snark tank. But I just do want to point that out in case you're new here. Argument. To avoid unfairly prejudicial speculation, this court should admit the fact that the U.S. Attorney's Office hired and retained the employees of ARCCA. Then they go on to say, proof of bias or lack thereof directly bears on the credibility of a witness. It is never collateral in nature, and extrinsic evidence to prove it is permitted. And then they talk about a lot of case law. In criminal cases, the defendant's right to confrontation provides a constitutional basis for admissibility. Indeed, a criminal defendant has a constitutional right to show bias. That is why all of Proctor's text messages came in, by the way, because they tend to show bias against the defendant. You know, even though he called them what? Unprofessional and unfortunate and regrettable. I think we can think of some stronger words than that. Indeed, a criminal defendant has a constitutional right to show bias. If a defendant demonstrates that there is a possibility of bias, even a remote one, the judge has no discretion to bar all inquiry into the subject. Bias is the relationship between a party and a witness. Oh, here, for those of you who want the legal definition of bias. And I just want to, oftentimes I point out my, pet peeves. Here's one of my pet peeves is when Twidiots are out there on the cesspool of Twitter. I know it's called X. I'm never gonna not call it Twitter. Never. And they say, let's say, with regard to the judge. This judge is so biased, B-I-A-S. She is so biased. Can I just point out that if you're saying that somebody has bias, the word is biased, B-I-A-S-E-D. I just want to point that out because I think it needs just a little public service announcement. Don't you see that all the time? The judge is so biased. Or, it's biased is an adjective. Thank you, Mudrucker. Thank you, Mudrucker. That really annoys me. Just one of my pet peeves. Just one. We might get to a couple more today. Here's the legal definition of bias. Ready? Bias is the relationship between a party and a witness, which might lead the witness to slant, unconsciously or otherwise, his testimony in favor of or against the party. Bias may be induced by a witness's like, dislike, or fear of a party, or by the witness's self-interest. Proof of bias is almost always relevant because the jury, as the finder of fact and weigher of credibility, has historically been entitled to assess all evidence which might bear on the accuracy and truth of a witness's testimony. That is citing a US Supreme Court case from 1984, which was a very good year. During the first trial of this matter, the defense was prohibited from mentioning the federal investigation into the investigation of this case. That prohibition extended, however, to the fact that the DOJ retained ARCCA, completely controlled the material they were to review and the testing they were to perform. To the extent that the Commonwealth impeached these witnesses by pointing out the material they did not review prior to performing their testing and forming their conclusions, the Commonwealth left the impression that the defense improperly withheld certain materials from those witnesses. That was a false impression and prejudiced Ms. Reed's defense by keeping relevant rehabilitation and credibility evidence from the jury. And I love that. I love that argument. Hey, Phoebe Mick. Yeah, we did go over the blood alcohol motion yesterday. I have time-stamped everything very nicely for you in the show notes, so you can go back and watch that later. The argument is the fact that you did not allow us to bring out the fact that the ARCCA witnesses were hired by the DOJ created bias against Ms. Reed. Worse, the inability of the defense to reveal and or explain ARCCA's initial involvement in this matter led to jury confusion that also prejudiced Ms. Reed. Post-trial, jurors contacted the parties and or made statements in public about the jury's view of ARCCA's involvement. At least one member of the jury surmised that ARCCA must have been retained by Ms. Reed's insurance company. That assumption would lead to an inference of bias in favor of Ms. Reed when none existed. At least one other member of the jury speculated that the ARCCA witnesses were seeking to insert themselves into the case for fame or other publicity. That assumption would lead to an inference that their testimony should be unfairly discounted. Importantly, identifying explicitly that neither the defense nor an affiliated third party initially hired these ARCCA employees is not only crucial to Ms. Reed's case, but is also relevant evidence that is inherently admissible. See Rule 402. It is also entirely true, as is the fact that the conclusions of the ARCCA witnesses were made before either party was even aware of the existence of the witnesses in any matter pertaining to Ms. Reed. Oh, the Bakers are here. Hi, Bakers. Hey, Bakers, what up? Thank you. If you guys don't, I'm sure most of you know who Broken Baker is, but if you don't, you should subscribe to his channel. He's from Denmark and he's awesome. I think it's Denmark, right? Cupcakes, bakers. Now I want some pastries. I think they're called the muffins over there, right? We love Broken Baker. Additionally, there are no permissible grounds under the Massachusetts Rules of Criminal Procedure. Massachusetts Rules of Evidence to exclude such relevant and exculpatory evidence, particularly in response to any hypothetical and or unsubstantiated concerns that unfair prejudice or misleading the jury. Muffin tops. Muffin tops. Well, I mean, isn't that the best part of the muffin? That's a Seinfeld reference, right? Remember when somebody, I think it was a Kramer, that wanted to start a muffin top company? Or was it Elaine? Just the top, because the top was the best part. And, you know, a muffin can be very filling. I can think of a Seinfeld quote for just about every situation. See Massachusetts Rule of Evidence 403. In fact, presenting to the jury that employees of ARCCA were initially hired by the U.S. Attorney's Office would serve to prevent juror confusion. Indeed, excluding such relevant and exculpatory evidence would mislead the jury. Right? And then they go on, and it's a little bit repetitive, but you know, you got to hammer your point home, right? The jury should get to hear relevant evidence, particularly that which makes a fact more or less probable than it would be without the evidence. And they go on to say, knowing that employees of ARCCA were not hired by the defense or Commonwealth and instead were hired at the time they performed their testing by a neutral third party, can and should add legitimacy to the credibility of these individuals' testimony, as the potential for bias or any other self-serving reasons for the defense's calling of said witnesses would thereby be eliminated, right? Let's eliminate the confusion. Eliminate the confusion. Don't confuse the jury. They're confused enough with your crappy jury instructions. And with all the spaghetti that Lally threw against the wall during the first trial, and the high tops at the waterfall, and the snow, and the band, and what were they playing, and how many witnesses testified before we even knew, before the jury even knew how John O'Keefe died? A lot. Essentially, okay, here it is. Wait. The information about the hiring of ARCCA employees, furthermore, could help the jury better evaluate the defense theories of back to one. This information about the hiring of ARCCA employees, furthermore, could help the jury better evaluate the defense's theory of the case. Here's the theory of the case. Are you ready? That Ms. Reed could not have been and was not responsible for the death of Mr. O'Keefe. Get it? That's the theory. It wasn't her, and it wasn't a car. They don't have to prove who it was. The jury doesn't have to try and figure out who it was. But if John O'Keefe was not hit by a car, and a car did not hit John O'Keefe, then we all go home. Right? That's all the theory needs to be. John O'Keefe was not hit by a car. Car did not hit John O'Keefe. Thank you, everyone. Let's go home. Can I turn what up a little? My voice? Can I turn what up a little? I'm not playing any video. I'm on automatic. I think I'm on auto audio. Yeah, I'm on automatically adjust the audio. I think you got to do it on your end, girl. That's right. It wasn't the jury's job to decide who did it. They need to hammer home reasonable doubt. And jurors, if you are sitting back there in the jury room trying to figure out what happened, that's reasonable doubt. That's it. Go home. You're done. You're done. Please turn up your vocal cords. Thank you. You're done. We all go home. We're out of here. Defense's theory, Discworld Edge Witch. Karen is not a Time Lord, and her Lexus isn't a TARDIS. Therefore, it's not physically possible for her to have hit John because physics. Yeah. Okay. Essentially, by clarifying who initially identified, hired, retained, and directed the investigation and testing performed by the employees of ARCCA, Ms. Reed should be allowed to substantiate her lack of culpability by presenting evidence that is an impartial third party vis-a-vis their findings corroborates her defense. In short, for the jury to properly weigh the credibility and accuracy of the ARCCA's Crash Daddy's testimony, it must know the full context in which these potential witnesses were brought in to opine on this matter. And then they say in footnote 3, the Commonwealth, of course, is more than welcome to cross-examine these witnesses regarding its allegations of bias or favoritism. They can do that. For these reasons, it is imperative that the jury in this retrial is made aware that the employees of ARCCA were initially hired by the U.S. Attorney's Office, eliminating any possibility that the jury believes that Ms. Reed or any related affiliates were the impetus for ARCCA's testing and analysis. And then they're going to go on for about 10 more pages. I'm going to scroll through it so you can come back and read it at your leisure and put it on a slower speed if you want. But I think you've probably heard this read 4 other times by 4 other creators already. And so they go on to say, acknowledging the objective fact that employees of ARCCA were hired by the U.S. Attorney's Office is relevant, probative, and would not confuse issues, mislead the jury, or otherwise cause an undue delay, waste time, or constitute cumulative evidence. Relevant evidence by nature is inherently somewhat prejudicial. That is why it is offered. Then they go on to talk about the rules of evidence. And I think this motion should be granted. Will the judge grant it? Who the duck knows? If I bet on any of this judge's rulings, I would have lost so much money. Although now that I know her better, I might just be like, rubber stamp, denied, denied, denied. Vegas should start putting odds on this stuff. Here, the fact that neutral third-party experts hired by the U.S. Attorney's Office corroborate Ms. Reed's fundamental defense that Mr. O'Keefe's injuries are not consistent with being hit by her SUV, nor is the damage to her SUV consistent with colliding with Mr. O'Keefe, is inherently central and foundational to the fair adjudication of this case. Oh, the uncivils are here too. Uncivils meet the muffin tops. The Bakers are here as well. Look at that. It's like a whole big family reunion. Hey, fam. Thanks, Kurt. And thanks, Broken Baker. Additionally, the Commonwealth has faced no unfair prejudice. The Commonwealth had the opportunity to cross-examine ARCCA's experts during voir dire in Ms. Reed's trial. And notably, the Commonwealth is privy to the testimony of ARCCA employees in Ms. Reed's first trial, right? You've had 2 bites at the apple now. 2. You know what they're going to say. They're not going to change their opinions. And the defense didn't pay them to hire them to formulate those opinions. Although they paid them after the trial was over, when they got drop mailed an invoice. Yes, they admit that. The defense acknowledges that this is an unusual circumstance, and accordingly, an unusual motion in an unusual case. Yeah, there is nothing at all normal about what is going on here. Generally, witnesses who are employed by the federal government testify on behalf of the Commonwealth, and defense counsel is unaware of any case in which a defendant has moved to preclude reference to the federal employer of a witness testifying on behalf of the Commonwealth. See how that works? Look at Tracy. Tracy gifted 50 memberships. Tracy, you are an amazing and kind mystery benefactor. Well, if your name is Tracy Walker, you're not a mystery, but holy welcome to everyone. There's over 6,500 people here. So 50 of you who are not already members are going. It's raining memberships. Hallelujah. It's raining memberships. Which is really so, isn't it so fitting for this trial, the It's Raining Men? Because didn't Jennifer McCabe say she was Googling that It's Raining Men video? Because, you know, family joke, it was real funny and all. And then it's come out later that no, she definitely was not watching the It's Raining Men video when she said she was. So there's that. Tracy, they're still coming. They're still coming. You're amazing, Tracy. Thank you. I think Tracy believes in justice too. That was wicked nice. Wicked nice. And not to be outdone, let's go here. Let's go back to the chat for a second because Pink Swan gifted 10 memberships too. Thank you, Pink Swan. You're amazing. So there's 60 coming out right now. You got to be opted in. You got to be participating in the chat, and YouTube chooses randomly. It's not up to me. If it was up to me, I'd give one to every single one of you, but welcome. Think you're going to like being a cupcake. People are like, why are you called cupcakes? Because there's a pink sign behind me somewhere. I don't know, maybe over there behind the daffodils. Look, I got daffodils. They're real. I have 5 children, and ever since I became a mother, I've had this pink sign that says, it's my daily mantra, because I would look up every morning and read it. You can't make everyone happy. You are not a cupcake. Any of you who have a lot of children know nobody's all happy at the same time ever. I am not a cupcake. I can't make everyone happy, but you make me happy. So you're my cupcakes. Colin did. It says, I'm in Stoughton now, bringing my daughter to dance. Just drove by Rich Schiffer's business, Canton Fence. Shout out to Canton Fence. Anybody who needs a fence, give him a call. Free Karen Reed. He's the rubber duck guy. That's awesome. Hot Water Boy is here. And thank you so much for your super chat. Colin did it. And good luck in Stoughton. Stay safe. Stay safe out there. Don't drive by D&E. Don't go to D&E. Don't go to McCarthy's. Don't go to Waterfall. Just stay away from all those places. Hot Water Boy says, I'm just a piano player. Free Karen Reed. I was calling Lally Water Boy for a long time because it seems like he's been demoted, carrying the book bag kind of thing, getting the water. But now that he's maybe in hot water because of the communications with Proctor and maybe his knowledge about some of the video maybe being altered, manipulated, destroyed, or hidden, he's in hot water. So I called him Hot Water Boy, and then people were freaking out, like, you can't call him Hot Water Boy, he's not hot. I'm like, no, like he's in hot water, and that's it. That's what I mean. Chloe Albert's Revenge says, Seinfeld was a show about nothing. The Commonwealth case is based on nothing. We are watching this poop show religiously. This is like an episode of Seinfeld. You're right. At the end of Seinfeld, remember, they all went to jail in the end because they were not good Samaritans. Remember, because they were mean people. They all went to jail. It was like a weird ending. I wasn't really happy with the ending, but of the series. Chloe Albert's Revenge goes on to say, maybe they should have submitted it to NBC instead. Seems like a real missed opportunity. Now, I think that if you were in a Hollywood writer's room and you scripted this and you were pitching this, and you had a pitch meeting, you're trying to pitch this as a pilot, they would laugh you out of there. Like, yeah, nobody's ever going to believe that. Come on. Nobody's ever going to believe that. Nobody would ever pick up that pilot. Iris, just finish your last video and feel like Sisyphus, never getting done. Haha. I think that's how you pronounce it. And greetings from Germany. Hi, Germany. The world is watching. Love you too. Thank you so much for your super chat, Iris, and we love having you here. Casey, can the defense appeal denied motions? They're very, very slim grounds for interlocutory appeal. I mean, interlocutory appeals are appeals that can happen before the case is finalized, before it's over. So, mostly evidentiary. We saw that in the first case. We saw that when the defense was looking for Brian Albert and Jen McCabe's cell phone records, and the judge denied it. It went up on appeal. The appellate court heard it. It was overturned in part. So they got Jen McCabe's cell phone records with regard to the Google search. Many of these denied motions can be post-conviction appellate issues. It is my opinion that there is no way in hell that Karen Reed will ever be convicted. But I hope that it answers your question. Thank you, Casey, for your question. If Levy left office, can Reed call him as a witness? No, I don't think so. I don't think that he's allowed to come in and testify about the things that he did during his time with the U.S. Attorney's Office. All that would be likely privileged. So my answer is, I don't think so. And I would lean towards no. BG became a member. Welcome, BG. Greg says you can go watch a neutral channel if you want. That's the thing. All the neutral channels have basically turned into free Karen Reed channels over the last year. Weird how facts can influence opinions, huh? Well, I mean, if you put that out there into the universe, people are going to say, well, the only reason that they're free Karen Reed is because, clicks and views and money. Do they really feel that way? I mean, all the creators that I know that I've been on their shows that are free Karen Reed now are 100% think this is insane. And even Vinnie Politian, who came on here, said there's enough reasonable doubt to drive a truck through, basically. But because of his personal experience with an entire family being killed by a drunk driver, he has very strong opinions about drunk driving. And so he does not, know whether John O'Keefe was hit by a car. And these are inherent biases that we need to work out during jury selection. Auntie Deb's Judicial Bench Award says, sorry, Melanie, I wasn't asking to turn up the sound. You're so sweet and attentive. Oh, you mean you want me to say it louder for the people in the back? Is that what you mean? Tracy, did you get another 20 memberships? 419? It's only 420, so you did. It's 420, everyone. For those of you who celebrate, you can celebrate because Tracy Walker is here and there's 20 more new members. I've learned to become much more sensitive to misophonia, which I never knew was a thing before. I really didn't until some viewers brought it to my attention that my swallowing into the mic was really upsetting them greatly. And so I try to be more sensitive to that now and turn off the mic. Like I never knew. People are like, yeah, it's really real. It's disabling. And thank you. So you're welcome. Reed's bite is bigger than Chloe's. Says you would think the judge would be concerned about all this. Also, I followed this case closely. I never saw those emails before. Where did they come from? They came from, I believe, a FOIA request. Sweet Caroline, if she's here, she can tell you. She's in the chat. Oh, KOB saw Maureen Hancock last night. All I could see was Auntie Beb. Did you see her in person? Like in person? She does some impressions of Judge Cannoni. I don't think she's free can't read, KOB. I don't know. I don't know about that. I heard that's what you guys were talking about in the chat earlier. Let's see. This was from 344. Sorry, I'm behind. Chloe Arbold's Revenge became a new member. Welcome. Cape Cod cred. Because Nivea lip balm is the best. We need as much as we can to smile for Karen when she's free. Thank you for the 10. I will order some more Nivea lip balm from Amazon, where I buy everything, which reminds me, a great way to help the channel without spending a dime is to simply shop through my Amazon link, which is in the show notes below, just to buy your regular things and stuff. A lot of people have asked me what kind of makeup I wear on camera, the color of my lipstick. Oh, let me see. And things like that. And there's lists of things in there, but you don't need to buy anything that I have recommended or that's in my list. If you just shop through my link and buy your regular stuff, it helps the channel. Let's see where that lipstick is. Why is it not here? Because I need some lipstick right now because I look like the crypt keeper. Hang on. Misophonia. Yeah. Never had a name for my weird affliction. Yeah, look it up. Misophonia. It's a thing. Oh, wait. Sweet Caroline answered. Hang on. Sweet Caroline said, the emails are on the Google Drive. Sleuthy Goosey put on X or Twitter way back. Sweet Caroline's doing her deep dive. She's doing her homework. Yeah, so I do suggest Nivea lip balm. And Benefit Roller Lash is my mascara, which I get asked a lot. And it's amazing because something about whatever the brush is made out of, I don't know if it's like a polymer. I don't know what it is, but it never clumps. It's amazing. I was always a Dior mascara girl, but that's way too expensive now. And Benefit is a little bit more realistically priced, and also it never clumps. And for the eyeliner, I do not wear eyeliner. I do not wear eyeliner at all. I find that it ages me, and I'm aged enough. So I gave up eyeliner a while back. Can't do the whole black eyeliner all around the eyes thing like I used to do when I was like in high school, remember? Or even like in the waterline. Makes my eyes look tiny, and it makes me look it ages me way too much. Glamasus, do you think ARCCA may have done more testing and modeling given all the information? Given all the information the defense has, my opinion is they did. If they did do more testing, we would know because the defense would have had to have turned it over. So if the defense gave ARCCA, let's say the key cycle information, the key cycle data, the text stream data, because that was, I think, what the Commonwealth was screaming about that they didn't have, that they didn't consider. And then their answer to that on the stand, well, yeah, it wouldn't change our opinion. Like, it doesn't matter. He wasn't hit by a car because physics. They would have had to have turned that over in their reciprocal discovery, and the deadline has passed. So if they did, We'd know about it, I think, already, Suze, but thank you for your super chat. Nina says, I think someone should start following the money. That's what we always say, Nina, when you want to figure out what's what, follow the money. Follow the money if you want to get to the bottom of anything. Thanks, Nina. We got to get out of this place. That's in there. It's the animals. It's on the playlist. The playlist is linked below. Spotify. Thank you, Sharon. Chris Albert got elected in April of 2023. Oh, so when those emails went out to Julie somebody in August of 2023 at the suggestion of Julie somebody, that video was made, maybe. Chris Albert was already on the select board. Okay, gotcha. Thank you. Camera Obscura says, the expert who did Gemma Cape's phone data would be nice to have, even though I can't stand that the defense still has to argue that point. Yep. Well, I mean, we're still here. We're still paying attention. Thank you for your super chat. Making Law Simple says, Melanie still owes me a Lego interview. I don't know what that is. What does that mean? Does that mean we actually are going to build Legos? Like, I don't even have enough space in front of me to build Legos, and I'm not very good at it. Or are we just going to talk about Legos? MLS, I know you came in, you gave me $100 super chat one time, and you're like, will you come do a Lego stream? I don't know what that is. The playlist is linked in the show notes below the video that we are currently watching. I do have a lot of Lego sets because one of my kids loves Legos. So I've got a million of those sets that are very difficult, but I don't know what that means. Email me. Thank you, MLS, making law simple. Mike says, I'm loving being a cupcake. Thanks for having me. Oh, Mike, you're a pleasure. You're a pleasure. The pleasure is all mine. Will Bev eventually be removed, you think? Nah. Because you know who decides whether or not she gets recused? If they make a motion to recuse her? She does. She does. They tried it, Kevin. I don't know if you were here for the last trial, but we did that pre-trial. And then recently, a couple Saturdays ago, just for fun, we reread the decision prior to the last trial where she did not recuse herself. And it was interesting because they had a lot of potential evidence that she may have some bias, may have some personal connections to some people involved in this case, maybe shares a beach with some of them. And even the appearance of impropriety should be enough for a judge to recuse. But she said, no way, no how. And I don't care because that Venmo that says for Frank and Beverly from Julie Nagel to Ryan Nagel or vice versa is not the way that I spelled Beverly. So there. And I've never rented my Cape house to anyone. Pat Chandler became a member. Welcome. Scott McGinnis is here. Hey, Scott. DA Meatball Morrissey is Captain Ahab seeking his Noah. His ship is full ahead. His crew is hopelessly stuck on board. Some have jumped overboard. An ill-fated voyage, and Bev is at the helm. Doom. All right, Scott. I mean, there's some positivity. Thank you, Dr. Russell is the goat for gifting a membership. I love you so much. Okay. Moving on. So basically, that's what they say. I agree with this motion. I think that it will give some clarity to the jury, and Lord knows, for the love of the travel and Mary, the jury needs all of the clarity and clarification that it can get. They go on to say that undersigned counsel is unaware of any case in which a defendant has successfully argued that eliciting the fact that a witness was employed by the federal government was improper, let alone caused her prejudice. So I guess they can't find any cases. And you know what I say, there's always a case. If there's not a case, it's because maybe this never happened before. And there is all that. Goes on for 16 pages. I think you got the gist of that, right? I think you got the gist of that. To deny her this would be denying her the constitutional right to present exculpatory evidence. And I think we can all agree that because of physics, because of the opinion by these biomechanical engineers who are also easy on the eyes, tall drinks of water, their opinion is that John O'Keefe was not hit by a car and a car did not hit John O'Keefe is absolutely exculpatory to Karen Reed, isn't it? And therefore, something else must have happened to John O'Keefe. And therefore, we should all go home. And yet, we're still here. We're still here. All right, let's look at 588, because this brings us to Lanka. And then we can watch some video because that'll be fun. I like watching video. Okay. This, of course, is a Commonwealth motion, of course. Of course. I mean, I'm a Rentschler girl. But I'll allow it, Michael. I'll allow it. But I am a Rentschler girl. We could take a vote in the chat. You guys can tell me if you're a Rentschler girl or a Wolf girl. There's that. All right. Commonwealth's motion in lemonade, whatever you want to call it. This is docket number 588. Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations, sustained findings unrelated to this case, or unfounded allegations of misconduct. The crash daddies. Maybe we should call them the crush daddies. All right. I mean, overwhelmingly Wolf, which is great because there's less competition. Like they're both married. I'm quite sure. But I know because the Twidiots are going after Dr. Wolf's wife. In fact, putting all of the pictures of their kids out there in the cesspool, and trying to intimidate Dr. Wolf from testifying for the sake of his family's safety, which is disgusting. Prohoc Ceviche, well done. Says watching videos like a movie day at school. Yes, we are at school. We're all in kindergarten. Because one day I was in someone else's chat, and I think I know exactly when it was. I think it was a day that I teleported you all over to Uncivil because he was going over the federal investigation. And the federal Paypizz. Thank you, everyone who reminded me that it's Jimmy 2 times from Goodfellas, who said everything 2 times and said, I got to get the Paypizz. And that's where I get that from. Jimmy 2 times from Goodfellas. It was in Uncivil's chat, and there was one person who says, I can't stand Melanie Little. She treats her chat like a bunch of kindergartners. And so therefore, it is now snack time during movie time. Go to your cubbies and get your snacks. And I have renamed my moderator, Scott, who's 25 years NYPD retired on the job, kindergarten cop. So there's that. I'm the teacher and he's a kindergarten cop, and it's a joke because you know what we do when people make fun of us? We make merch. About it. For example, for those of you who don't know the lore, let's just do a little story time for a second before we get to this about Lanka, because that's more lore that you need to know. So about a year ago, I started covering this case in January of 2024. And then in February of 2024, I love Dave Matthews. And so I, go see him every chance I can. I follow him around like I used to follow the Grateful Dead around, but now I follow, Dead and Company. Vegas, Sphere's coming up. And so last year, every year, Dave Matthews and Tim Reynolds do 3 shows on the beach in Cancun, and it's like a whole thing. It's like a package. Like you go and you buy the package and you get to see 3 shows on the beach in Cancun, and it's amazing. You could even be in the water. You could be in the water and watching the show. It's like a big sing-along. It's like only 5,000 people. You can get right up to the front if you want. It's like a whole thing. It's fun. It's all inclusive. They have waiters walking around and waitresses with trays of drinks and margaritas and beers, and it's all inclusive. So it's like, and they just bring drinks. They come around. They pick up. It is fabulous. I highly recommend. Fish also plays there every year, as does. They do like a thing called Crash My Playa, which is like Mount Joy was there. That's right. Mount Joy was there. I don't know if it was this year Mount Joy was there. I'm not sure. It might have been the year before. This year was refresh my recollection. Huron. What are they called? Something Huron. I don't know. Anyway, you're in Cancun right now. That's amazing. Last year, it was Mount Joy, right? Look at Nancy's in Cancun right now, listening to us. So they do Crash My Playa, which is like a country thing. I think it's maybe like Luke Bryan. And then they do, it used to be Dead and like a Grateful Dead thing. But John Mayer, I guess, doesn't like to go to Mexico, or maybe he can't. I don't really know. But and now it's Bob Weir and Friends, kind of like. And every year, like they do like 10 in a row of like cool events, and they do a Hootie Fest with like Hootie and the Blowfish or Hootie, Darius Rucker, and it's fun. Anyway, so last year I went, it was in February, and I came back and we were watching a hearing for Karen Reed, and Alan Jackson had this like cool bracelet on that was like one of these bracelets that I got in Cancun. And I said, oh, I wonder if Alan Jackson was in Cancun. That's like one of the bracelets that I got at the Dave Matthews concert in Cancun. Well, the telephone game started, and all the Twidiots who started attacking me ever since I started covering Karen Reed started a rumor that I was in Cancun with Alan Jackson. And that became the rumor, and it was like wildfire. You know how rumors happen. And so then one day, Grant Smith Ellis, who, if you do not know, is a Lord Huron. That's who it is. Thank you, Lord Huron. Yes. Take me back to the night we met, which is from the movie, the TV show, The Affair, which I also love. And I think that Whitney's wedding scene where they did the flash mob dance to The Whole of the Moon is one of my favorite all-time scenes of any TV show ever, but I digress. Grant Smith Ellis was at the courthouse. I had never met Alan Jackson. I had no idea if Alan Jackson even knew who I was. Grant Smith Ellis, who is the son of Wendy Murphy, who's an attorney apparently somewhere, who thought that she went after the Duke lacrosse players. Anyway, Grant Smith Ellis chased after Alan Jackson. Now, he's got one of the greatest trial lawyers of our day in front of him. And the question that he chooses to ask Alan Jackson is, did you have fun in Cancun with Melanie Little? And then shoves his phone in front of his face. Alan Jackson kept walking, but Grant Smith Ellis did not quit. He chased him up those steps. And he said, did you have fun in Cancun with Melanie Little? And so, here's what you do when they come for you. You make merch. So there's merch for that. I just decided the other day, like they don't bother me anyway, these trolls, but we might as well laugh about it, right? We might as well. So, for those of you who are interested, the sale is over. Yesterday was the last day for the 15% off. The link is in the show notes there below, but, you too can have your own. I went to Cancun with Melanie Little, with attorney Melanie Little merch. There it is. Comes in lots of different colors and lots of different styles. And there's nice t-shirts. And there's also merch that says like free Karen Reed on the front and the I went to Cancun with attorney Melanie Little on the back. And it's great. And that's why, and look, it's got a little nod to like the dead in there. Like there's a skeleton holding a beer bottle on a surfboard inside. It says established 2024, because that's when the rumor was established. And so thanks, Grant Smith Ellis, for the idea, and for whoever the initial Twitty it was who put that out there into the Twitterverse and made that whole entire ridiculous thing. Hang on, because there's more. Where are the designs? Let's see. The Bella and Canvas stuff is the softest. So this one says like free Karen Reed on the front, and then it says I went to Cancun with attorney Melanie Little on the back. And then there is also like the baseball style shirt. I think this is the back of this one. It says free Karen Reed on the back, and then the front says I went to Cancun with attorney Melanie Little. The link is in the show notes below if you need it. You may need it. Here's free Karen Reed, and on the back of that one. And then there's another one, another design that has stay cool, stay kind, stay classy on the back of it. Let me see where that is. Oh, we have it strains credulity. We've got that too. And we've got the tie-dyes too for that. The tie-dyes didn't really go with they didn't look right on the new designs. So there's also this free Karen Reed on the front, and then on the back, we are outraged. Stay cool, stay kind, stay classy, attorney Melanie Little. So there's that. Okay, that was a little story time break. Now we go back to docket number 5 and 9. No, wait, we were not doing 591. We were going to do the other one. We were going to do the Lanka one so that we could watch a little video and have a little video story time. And that would be docket number 588. Where are you, 588? Where'd you go? Just disappeared. Where's the Paypizz? There's the Paypizz. Okay. Ready? Here we go. Talking number 588. The Commonwealth moves in limine to prohibit disclosure or reference to any internal affairs investigations pending against any law enforcement witness. The Commonwealth further moves in limine to prohibit disclosure or reference to any internal affairs investigations with sustained findings, as they bear no relevance, nor do the findings relate to any bias exhibited by those against whom findings have been made. Okay, so this is a Commonwealth motion, obvi. But here's the thing. The reason for all of these internal affairs investigations, for example, against Fanning, Buchanan, Proctor, who else did they internally investigate? The reason they were all investigated is because of the Karen Read case. It's because of what happened at Karen Read's first trial. It's not like these internal affairs investigations were the result of some other misconduct or misdeeds or bungled investigations or lies. It is because of this exact case that these many in Tully, was it Tully also? Tully, Kevin Albert. Yep. Thank you, Olivia. Thank you. So we got Fanning, Tully, Buchanan, Kevin Albert, brother of Brian Albert, go figure, Proctor. Kevin Albert is the one who went with Michael Proctor on a cold case investigation to the Cape. And they had a whole bunch of beers. Even got some roadies, I think. And then the next day, Kevin Albert texted Michael Proctor and said, "Dude, where's my gun? Dude, where's my gun? Where's my badge?" Because they were allegedly maybe so hammered while on duty in a company car. Yeah. Probably. That's what they're trying to prevent. The got drunk, misplaced badge and gun. Well done, Ambling Soul. That happened after the death of John O'Keefe, right? I don't think that predated John O'Keefe's death. The badge and gun drunk fest. But Tully, Proctor, Fanning, Buchanan, maybe Kevin Albert is the lone wolf who was not officially investigated for the things that happened in the Karen Read case, but the rest of them were. I say fair game. Okay? But who knows? The judge probably will. I don't know what she'll do. But listen, we know Karen Read is not getting a fair trial. We already know that. I think I've seen this film before and I didn't like the ending. Name that tune. Boozy Beauty would know if she's here. I think I've seen this film before, but I didn't like the ending. Team Brittany will know. Name that artist, name that tune. That is Swift. It is a Taylor Swift song. That is true. Don't forget Trooperino. Was Trooperino, did he have an internal affairs investigation and Lank? I don't know if they did. Did he? Aries Girl, I think, was the first to say it was Taylor Swift. Exile. Thank you, Lindsay L. It is. And who sings that duet with her? That's the bonus question. Who is her? Who sings it with her? Who sings the man part? I know you know. Fat, Dumb, and Happy was just singing that song. That's right, Bon Iver. That is right. Clarabelle. Is that how you pronounce it? Bon Iver? I say Bon Iver because I think it should be French. JB knows. Well done, you guys. Well done, chat. Maybe we should. I think I need to put. I love when I quote Taylor Swift too because my girls are Swifties, you know, yes, I know you step out for 1 minute and Taylor comes into the chat. I know, no haters, please. She's one of the greatest performers that I've never seen. One of my daughters was able to get tickets for, I think it was MetLife Stadium, and she had an amazing time. And you know what? I tell my kids, like, there's always a ticket. And go. Just go. There's always a ticket. Spend the money, make the memories, get the tickets, do the things that make you happy. Okay. But that's me. I love music, and so do my kids. And I go with them. I took my daughter when she was 6. Quick story. She was a huge One Direction fan. And when she was 6, I took her to her first concert, and we went to Buffalo to see One Direction because it was cheaper than going to Madison Square Garden or wherever they were playing here. It must have been a stadium because it was a stadium tour. So that was probably, I don't know, 10 years ago. And she was 6, and we saw One Direction, and it was amazing. It was amazing. Amazing. Girl's got to see her favorite band for her first concert. That's what I say. That was amazing. Buy the tickets. Go. Like, you never know. You never know what's going to happen. You never know when somebody's going to die. Like, and you might not be able to see them. I'm still upset. I never saw Tom Petty. I never got the chance. Just go. Music makes me happy. All right, here we go. Moreover, the Commonwealth moves to prohibit reference to any civil lawsuits filed against Canton Police Sergeant Lank relating to an incident that occurred nearly 20 years ago. In the federal lawsuit previously relied upon by the defendant, there were no adverse credibility determinations against Sergeant Lank or any findings of liability. The case was dismissed by agreement of the parties. Oh, Mr. Brennan, you might be new here, but it's called a settlement. It's called a settlement. You don't dismiss a case by agreement of the parties. You discontinue a case by agreement of the parties. It's called a stipulation of discontinuance. And you file that when the civil case is settled. And then once the plaintiff signs that release and sends it to the party who's supposed to pay the judgment or the settlement amount, once they have that signed and notarized release saying how much money you're going to pay, then you hold that release in escrow. You send the money to the plaintiff's attorney so that the plaintiff can be paid the settlement funds. And then you file that stipulation of discontinuance with the court clerk. It's not dismissed by agreements of the party. It is discontinued. There's a difference. Who knows how much Canton paid in settlement of that lawsuit by the Lopalito Brothers. Lopalito. I'm sorry. I know I pronounced it wrong because I can't remember even how it's spelled. Part of the settlement agreement, says Suze, was that Lank was not to not ever be promoted. I don't know if they can make that part of the settlement agreement, but you say he's been promoted twice that I'm aware of. Typically, civil lawsuits involve money and nothing else. So, I as a civil litigator for over 30 years, I would say that is typically not something that would be part of a settlement agreement. In this case, was it? I have no idea because, again, land of the lost. We're in the land of the lost. Thank you, Sky Bell, for gifting a membership. You're the sweetest. Positive vibes. We all need the positive vibes. So thank you so much for becoming a member because we need you so much. Kevin says, gorgeous with or without lipstick. Don't worry, I'm gay. Don't worry, Kevin. I will take compliments from anywhere they come. I don't care. The lesbians can compliment me. The gays can compliment me. There's nothing better than a gay man complimenting you, by the way, because you probably have an excellent sense of fashion. Thank you so very much, and I appreciate you. Dirty Hanky says, we live in the land of confusion. Genesis, that's always, oh yeah, girl, that is on the playlist. Girl or boy, Dirty Hanky, that's on there. And also I added the disturbed version of Land of Confusion, which one of you guys turned me on to. You sent it to me and I allowed it. It's on the playlist, I think now. And recently, here are the recent additions due to popular demand. We added a bunch. They're at they're kind of in order of the way we started the playlist. And it starts off with Taylor Swift, coincidentally, Who's Afraid of Little Old Me. There are currently, let me see how many songs we have on here. Does it say? Like almost 100 songs, I think. Who's Afraid of Little Old Me? I don't remember. Peter Gabriel, Road to Nowhere, Lollipop. And then as we get down to the ones that we just added on here, we started with Seven Nation Army by the White Stripes, Right Through You. We got a little Alanis Morissette. We're Not Going to Take It, Twisted Sister, When the Levee Breaks, a little Led Zeppelin in there. We got some Jerry Garcia band in there, My Sisters and Brothers, Keep the Faith. The Light by Disturbed, Manic Monday, Bangles, Please Don't Go, Casey and the Sunshine Band. And once you said that to me, Mama She, I could not get that song out of my head. And I was brain dead. And I'm like, what? Please don't go. What? And now I can't, it's a worm in my head now. Of course I know that song. Don't we all? Don't go, don't go. Okay. And then Stuck in a Moment, You Can't Get Out of, U2. That's a nod to Karen Reed because she has said that U2 is her favorite band. We've got Renegade in there by Styx. The Jig Is Up. The News Is Out. She's Already Made Up Her Mind by Lyle Lovett as a nod to the judge in this case. And then we have Miley Cyrus, Wrecking Ball, because they came in like a wrecking ball. And they still continue to come in like a wrecking ball. So thank you very much, Dirty Hanky, for that. And it just came to my attention that I did not add the Disturbed version on there, so I will. So here we go. With their nonsense of why they don't think that any of the misconduct of any of their law enforcement officers should come in any way, shape, or form, because the Commonwealth should have a fair trial. And they cite some case law, which I haven't read, so I can't really opine further. Then it says, further, they say that in other cases where sustained findings have been issued, which do not reflect untruthfulness on behalf of the officer, nor exhibit any bias against the defendant by the officer against whom sustained findings have been made, the conduct is equally inadmissible and lacks relevance. Well, that's the thing. Kevin Albert was not involved in the Karen Reed case, was he? But you know what? He kind of was. He collaterally was involved. He was never called as a witness, but he was involved because didn't he set up the interview of Katie McLaughlin to take place at Canton PD? So he kind of had his fingers in it. And I think that came out when the feds dumped that TUI material on both sides. And it came out, I think, during some testimony. So even though Kevin Albert was the subject of an internal affairs investigation, and I think they only took away like 5 vacation days for the lost gun and badge thing. You can't always get what you want. Thank you, Trident. I've been meaning to put that on there. I haven't done it yet. Thank you for reminding me. Come to My Window has been stuck in my head for days. Yeah, that's going on there. That's going on there. Thank you, Sherry Ann. You guys are awesome. Yeah, I agree with you. BG, ain't nothing going to happen to Proctor until after trial is my take. I think so too. Is his hearing supposed to be tomorrow, his day 3 of his Massachusetts State Trial Board proceeding? Is it tomorrow or is it like the 18th? So yeah, Kevin Albert kind of was involved, although they tried to pretend that he wasn't involved and they tried to hide the fact that he wasn't involved, just like the fact that they tried to spell all of the witnesses' names wrong in the initial police reports, right? Yeah. So there's that. Further, the Commonwealth requests advance notice and production of any reciprocal discovery related to any specific instances of prior misconduct or false statements that the defendant seeks to introduce or use to impeach any law enforcement witness. Well, this goes around with, along with anyway, the fact that in this trial, apparently, or Massachusetts or wherever the hell we are here, because I'm beginning to think she is the gatekeeper to the gates of hell. The defense is required to turn over all impeachment evidence to the Commonwealth so that they can prep their witnesses to be impeached and get ahead of it like they did in the last trial. Here's the thing, Mr. Brennan. They're your witnesses. They're employed by you. They're your law enforcement. If you don't have your own law enforcement's prior misconduct information, that would be insane. That information is in your custody, possession, and control. Why should they have to give it to you? Well, because, they're allowed to take away your smoking gun in this courtroom anyway, in the gates of hell. Okay, so for those of you who are like, well, what is this 20-year-old lawsuit about? Well, I'm going to lay the lore on you today. We're going to lay the lore. We're going to talk about it. And not only it's movie time, everyone. Everyone go get your snacks from your cubbies. If you need some water, you need to use the ladies or the men's room, I'll let you go. I'll give you a pass to go. We're going to take a look at the voir dire that took place on day 5 of Karen Reed's trial, because the defense wanted to bring in this information about the fact that Sergeant Lank, Michael Lank, has been the fixer, inserting himself into Albert family business for decades. And so it is the defense's contention that on the morning of January 29th of 2022, they weren't just going to let anybody come into the house at 34 Fairview. No, they had to wait. They were waiting on a friendly. Who's the friendly? Lanka. That's right. Lanka. Lanka's the friendly. Lanka's been inserting himself into Albert family business for decades. Let's listen to a little bit of the voir dire. This might trigger some PTSD for some people. Because, the fan, the judge, the stare downs that are going on. Hang on a second. Everything was at sidebar. So there was a sidebar here. I'm trying to fast forward it while you're getting your snacks to the proper place so that we can take a look and rewind ourselves back to May 6th of 2024, where the defense team was required to do some questioning of Lanka before the judge would determine whether or not he was going to be allowed to testify to this very story. Fight song. That's right. Is that on there? I don't know if fight song might be on there. Might be on there. All right. Let's go back to May 6th of 2024. Come with me, if you will. Back to May 6th of 2024. Back to the little tiny courtroom. This is day 5 of the first persecution of Karen Reed. The little tiny courtroom. And we will see our friend Craig of the little tiny desk also. She sent the jury out of the room. And here it comes.
If you happen to see, hear, or read anything about this case, please disregard it and let us know. So we'll see you tomorrow morning. Tomorrow morning's a half day.
Tomorrow morning's a half day.
Close your notebooks, leaving them on the chairs, taking all your belongings, follow me, all rise.
Close your notebooks, leave them on your chairs, because Fanning is not going to pick up your notebooks and read them. We promise. He never stepped foot into the courthouse. He never had anything to do with that jury. Next court date is next Tuesday and Wednesday, full days to argue the motions in lemonade and all the motions that we've been going over. Thanks for asking, Mark Baumeister. Okay. Leave your notebooks on your chairs. We'll see ya. Tomorrow's a half day. It must have been Taco Tuesday. Maybe it was half day Friday or half day Wednesday or stay in Cape late Monday. I'm not sure.
Goodbye.
Free Billy Tibbetts. See how they zoom in and you can see lip readers might be able to. I can also hear him on the mic, and he has to stand so close to Paul O'Keefe. The stare down. Yes, that is Erin O'Keefe here on the right of your screen. And to the left of her, as you're facing the screen, is Paul O'Keefe, mother of Jonathan. There's Grant Ellis right there. Hi.
All right, so someone needs to.
That's the guy right there. Mr. Jackson, did you have a nice time in Canton with Melanie Little?
Maybe seated.
All right, so someone needs to get Sergeant Lank for you. Okay, so the voir dire, I thought that we would have finished this earlier and I'd be able to give you more time, but I suggested 10, 15 minutes. Mr. Jackson tells me that's fine for him and the Commonwealth as well. So what I'd like to do is 10 to 15, 10 minutes would be great from each of you, and then I'll hear argument because it means now I'm keeping the staff longer than necessary. So, all right.
Oh, please. We know you want to get to Taco Tuesday.
Is he here?
Do you believe this? Do you believe this? Scrolling along the bottom of your screen.
Yeah, it's right.
is what we are watching right now. This is day 5 of Karen Reed's original persecution, May 6, 2024, Lank Voir. This is what they want to keep out. For those of you who don't know the lore behind the little, I think it's Lopalito Brothers, but I'm not sure how to pronounce it. Could be Lopalito. What adult put stickers on their laptop? That's a great question, Kate. It's rhetorical. Are you guys getting PTSD from just even like this view? Like it's giving me a stomachache. But I'm gonna push through for you. Yes. Good one, Green Eyed Southern Girl. Don't stand so close to me. The police love the police. And here is the fan, everyone. All right, so I guess they took a little break so we can fast forward a little bit.
You may be seated.
Wouldn't it be funny if we saw fanning in the courtroom?
Goes back to session. You may be seated.
Is the witness here?
That's Jim, the court clerk. Lally doesn't have his baby shark hairdo today, this day. Hot mic. Oh, there's Craig at the tiny desk. I made him sit at that little TV tray table. And he and Sergeant Lank. They don't want this stuff coming in this trial. Yeah, Mass Dad, you do like Jim. Jim is very helpful. He's a good guy. He's a good guy. We don't disparage Clerk Jim here. Because you know what? I think Clerk Jim runs that courtroom.
Please watch your step to the stand, please. The clerk and raise your right hand.
Do you solemnly swear the evidence you give the court in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Mayor, Your Honor.
Please.
Thank you. Thank you for joining us late in the afternoon, Sergeant Lank. I'm going to direct your attention.
Wait, I just wanted to point out how she was so annoyed that they went longer than she thought they were going to go. And then she's going to have to keep the court staff late. And then it's going to be a whole thing. Somebody told me that it's required that they get their lunch break at 1 p.m. I always thought it was just the judge wanting to break at a really important part of testimony or when the defense was in a really good flow. But apparently maybe it's union contract or union rules that court officers and everyone in the courthouse has to take break at 1. I don't know. You guys can tell me if I'm wrong, but maybe it's also, there's also a contract that they can't work past 4. I don't know, but she doesn't like to work past 4. We do know that. And look at Mel's K-12 teacher, number 1. You're my number 1 student. Are you ready, kiddos? Here we go. Mrs. Parks, 87. Hey, it is scrolling below. We are going back to figure out why Hank Brennan has decided to make this motion to keep out all of the internal affairs investigations of all the law enforcement witnesses whose internal investigations and IA investigations are a result of the Karen Reed case, and also what he wants to keep out about Sergeant Lank being the fixer for the Albert family for decades. And here is day 5, May 6, 2024, Lank Voir dire, scrolling below on your screen. If anybody is joining late and wants to know what it is, just tell them to look at the scroll. Thank you.
To your relationship with the Albert family and some of the members of the Albert family. Do you know who Tim Albert is?
Yes.
Do you know who Chris Albert is?
Yes.
Do you know who Brian
Can I
Albert?
interrupt? I just need your name for the.
I'm so sorry.
Madam
Can you
Court
please state your
Reporter.
name?
Did we hear Madam Court Reporter? I think that's the only time we ever heard Madam Court Reporter speak in this entire trial. Yeah, you have to state your name for the record and spell it.
Name and spell your name for the record, please.
Michael Lank, L-A-N-K.
Michael, common spelling?
Yes,
I'll start over.
Sure.
Do you know who Tim Albert is?
I do.
And do you know who Chris Albert is?
We don't want to
I
get
do.
sued.
And do you know who Brian Albert is?
I do.
How do you know Tim Albert?
I know Tim Albert to be one of the younger brothers of the Albert family
How long have you known Tim?
since childhood.
What about Chris Albert?
Since childhood.
Yes, I know Chris.
How long have you known Chris?
How many Albert brothers are there? Remind me. 6? 6 maybe? 6 Albert brothers? They're like, you know, they were like the talk of the town. Like every girl wanted to date him. Everybody wanted to marry him. Chris, Tim, Kevin, Brian. Were there 5 brothers? Too many. But he's known Tim since childhood. 6 brothers. Thank you, Prohawk Beache. I know it's going to relight your fury over this case, but you know what? You know what? For the newcomers, For the newcomers, we welcome you with open arms. We welcome you with open arms because the world is watching. And for newcomers, you might not know all of the twisted family tree roots that are happening in Canton. Okay. This is Sergeant Lank. This is the friendly. This is the guy that they let into the house to tell him the other guy never came in the house. He's been involved with the Alberts since childhood. Listen.
Since childhood.
And how would you describe your relationship with Chris Albert?
Yes, I know Chris since childhood, the Albert family.
How long have you known Tim?
Since childhood.
What about Chris Albert?
Yes, I know Chris
How long have you known Chris?
since childhood.
And how would you describe your relationship with Chris Albert?
Chris and I were pretty good friends growing up, right into our 20s. Still friendly when I see him.
Still socialize with him?
No.
Okay. I'm just going to point out Chris Albert is Colin Albert's father, husband of Julie Albert, who may or may not have suggested that Michael Morrissey make a hostage video. Chris Albert is also now the town selectman. Lanka has been friends with Chris Albert since childhood. Okay. Just when you thought it couldn't get any more ducked up, it's getting more ducked up. Please check the scroll at the bottom if you're just joining to tell us what we are talking to, so that you can see what we're doing here. Because I can't stop to explain every 5 seconds, but I will, but I won't. No.
When did you last socialize with Chris Albert?
I couldn't tell you the last time I personally socialized with him. I've seen him at events, but Chris and I don't make arrangements to go out together.
What about Brian Albert?
No.
How would you describe your relationship with him?
Civil.
Friendly?
Exchange pleasantries when I see him. Hello.
But you're closer to Chris.
Yes.
Have you ever described yourself as being a longtime, quote unquote, drinking buddy with Chris?
No.
Would you describe yourself previously, in years past, as being a drinking buddy of Chris?
No.
Have you ever gone out for drinks with Chris?
Not in years.
Ever?
I don't think Alan Jackson asks a question that he doesn't have a receipt for, do you?
Yes.
So you've socialized with him in circumstances in which y'all are drinking and imbibing.
It's been many years, but yes.
Your relationship with Chris certainly goes all the way back to 2002.
Again, we were friendlier back then, yes.
Right. Back in 2002 in August, while you were off duty, were you out either drinking with Chris or in some way at a restaurant or a bar with Chris?
No.
Were you close in proximity to Chris when he was out drinking and at a bar?
No.
Was he at a restaurant?
I don't know where he was.
Were you at a bar?
I was.
At some point, did you realize that Chris was getting into some sort of a physical altercation with somebody else in a parking lot?
Yes.
Did you jump into a fist fight in order to protect Chris Albert?
Chris actually approached my vehicle and started to describe an altercation that had been in previously in the night.
Mm-hmm.
When you say your vehicle, your personal vehicle?
Yes.
Okay, so you were off duty, is that right?
Yes.
You've been drinking?
Yes.
Nothing wrong with that, but just
Yes.
so happens that you've been drinking that afternoon.
Yes.
Not that there's anything wrong with that.
Tim Albert was with Chris, correct?
Not when I saw him, no.
Okay. Ultimately,
Remember, the jury was not in the room for this. This was so that the judge could decide whether or not she was going to allow this testimony, and she wanted to know what Lank was going to say all the way back May 6th, 2024, day 5 of the trial that went on for I don't know how many hundreds of days.
when you realized that Chris Albert was in some sort of fracas, some sort of fight or altercation, you activated yourself as a police officer at the time.
He wasn't in a fracas when he approached my vehicle. He approached my vehicle and stated that he had been in an altercation earlier in the night with one of the Lopalito brothers, and that during that altercation, threats were made against him and his family, and he was seeking advice because he knew as a police officer as to how he should go forward. And as I was telling him what to do, that's when a group of men started to walk down Washington Street towards Chris. And he said, "Oh no, here they come."
So that would be Mark Mom.
Oh no, here they come. Lopalito is how he's pronouncing it. Maybe I'll allow it. You could tell, you could see his mouth is so dry, right? You know, because we, a lot of you watch like body language experts and Sergio Gennaro, the Truth Revealed station, and he talks about how he can tell when people are not being truthful. His mouth is really dry. Look at it, he's licking his lips. I don't know what Sergio would say about that, or the body language guys would say about that. He's gonna use semantics here to try and get out of it. Well, no, you know, he wasn't in a fight, but you know, he wasn't walking towards me. See how he's like trying to like, Chris needs to come and then get somebody to bail him out of trouble, or what should I do? Asking what I should do. Like what? Should he go beat him up? All right, listen.
Lopalito, correct?
Yes.
And his brother Alfred.
Yes. Alfredo.
Alfredo, sorry. You got out of your car and approached the other men.
Yes.
You also called for a Canton police backup.
I brought my attention to the restaurant owner and a bartender who had walked out into the street, and I yelled for them to call the Canton police.
Canton police did in fact arrive, correct?
They did.
Isn't it true that
You yelled for them to call Canton police? You're yelling? You're an off-duty police officer and you're yelling for them to call the police? Like, anybody know what bar they were at? I forget now. It was like a bar that is now something else. But they've been doing this since at least 2002. Yes, they did. The brothers eventually won a civil suit. Do you know how long that was? How much that was settled for?
after you got involved and Canton police arrived, you then instructed some of your colleague police officers to handcuff Alfredo?
I can't recall.
Isn't it true that after Alfredo was handcuffed and, for all intents and purposes, physically incapacitated, you then approached Mark Lopalito?
No.
You got into a fight with Mark Lopalito, though?
Yes.
You punched him in the face?
At one point after he had struck me, yes.
So your story is he struck you first and then you punched him.
Yes.
His story, of course, is you punched him first.
I don't know what his story is.
Well, you were sued in federal court and he told you his story in that lawsuit, correct?
So I actually have a question. The criminal case was adjudicated. The civil case, I did sign a non-disclosure, so I'm not sure if I can speak on that.
I will never ask you what the nature of any settlement within that case was. Just the fact that you were sued in a public document, which a federal lawsuit is a public document. You were sued in federal court over this incident that I'm talking about, correct?
Yes.
And ultimately it was settled. I'll never ask you what the terms of the settlement are.
It was settled, yes.
Okay. Ultimately, you said that the criminal case was adjudicated. We'll get to that in just a second. Did you testify at that criminal case?
I did.
All right. I want to sort of tailor this a little bit because we're on a little bit of a time crunch and I want to be sensitive to the court's time and your time. The allegation that Mark Lopalito made against you is that you punched him, took him to the ground, continued to beat him, and bit him to the point of drawing blood, correct?
I believe that was his allegation, yes.
Sergeant Lank bit a man. Sergeant Lank bit Mark Lopalito in 2002 when he was off duty to defend the honor of Chris Albert. They don't want the next jury hearing about this. That's the motion we just went over. Let's keep listening.
That once the police officers that were there pulled you off of him, you then turned and walked over to Alfredo while he was still incapacitated, meaning physically handcuffed, and spat in his face.
I believe that was his allegation, yes.
Ultimately, both men, after this altercation, were allowed to leave the location, correct?
I believe one fled and the other one was allowed to leave, yes.
Okay.
Okay, just to recap. He bit Mark Lopalito. He bit Mark Lopalito, and he spat at Fredo Lopalito. One of them ran away, and then let's see what happened to the other one. AJ says he learned from Chloe. He's a biter.
You're telling me now that Mark Lopalito punched you first, a police officer, correct?
Yes.
And are you aware of any circumstance in which an individual would be able to punch a police officer on duty or off duty in the presence of other police officers and just be released? That wouldn't happen, would it?
I don't believe the other police officers were on scene when the fight initiated.
Did you tell them that you got punched?
I don't recall.
They certainly let Mark go, correct?
Mark fled.
Okay. And then
Alfredo was released.
so the
ran
next
away.
day, Mark and Alfredo
If you
showed up at Canton PD to file a complaint against you and some of the other police officers that were involved, correct?
That's what I was told. I wasn't there.
You didn't file a report for assault or battery or anything like that, correct?
I spoke with my sergeant that night, and he said that I could do the report when I came back in on my next day of work.
My question is, on that night, did you file a report?
No,
The next day, did you file a report?
I don't recall if it was 1 or 2 days later.
It's actually 3 days later, wasn't it?
I'm not sure.
Does it sound like that's in the time frame? It probably was about 3 days later.
I honestly couldn't tell you. It's 22 years ago. I'm not really sure.
But between the time this fight happened and you filed a report, Mark Lopalito and his brother Alfredo came into Canton PD and asked to swear out a complaint against you and fellow officers, correct?
I believe so.
And they were told to go away on that day.
I couldn't speak to that.
By the time they came back to file the complaint, then police reports had been written, right?
I don't know.
Don't lose sleep. Don't lose sleep, Mickey. I'm really
Once those
busy.
Police reports were written after they indicated that they wanted to file a complaint. Ultimately, charges were brought against them, correct?
Again, ultimately charges were brought. I don't know the exact timeline.
After charges had been brought, and both brothers ended up having to go to court and defend themselves, you ran into both brothers at a mobile gas station.
Yes.
Oh yeah, this gets
You
better.
confronted both brothers, correct?
Just when you thought it couldn't get better.
You approached both brothers.
No.
Isn't it true that you walked up and said, "How you doing?" to the two guys? And one of them responded, "Not so good. You attacked me and now I've got to go to court."
No,
That conversation?
I believe they initiated the conversation with me.
Did you say, "How are you doing?"
Something to that nature.
And did they respond? Something to the effect of, "I'm not doing so good because you attacked me and now I've got to defend myself in court."
I don't recall exactly what they said in response.
And then, based on that interaction, you arrested them for witness intimidation, correct?
Well, there was further interaction. It wasn't just the response to "how are you doing?" They made threats and they were ultimately arrested. Yes.
Witness intimidation. They've been weaponizing the witness intimidation statute since 2002 at least. Did you hear that? You arrested him for witness intimidation. Let's hear that again. Okay, Mickey, I'm sorry that you're losing sleep, honey. Try not to lose sleep. Try and do something else. Distract yourself. Listen.
And you filed a report. Mark Lopalito and his brother Alfredo came into Canton PD and asked to swear out a complaint against you and fellow officers, correct?
I believe so.
And they were told to go away on that day.
I couldn't speak to that.
By the time they came back to file the complaint, then police reports had been written, right?
I don't know.
Once those police reports were written, after they indicated that they wanted to file a complaint, ultimately charges were brought against them, correct?
Again, ultimately charges were brought. I don't know the exact timeline.
After charges had been brought, and both brothers ended up having to go to court and defend themselves, you ran into both brothers at a mobile gas station.
Yes.
You confronted both brothers, correct?
No.
You approached both brothers.
No.
Isn't it true that you walked up and said, "How you doing?" to the two guys? And one of them responded, "Not so good. You attacked me and now I've got to go to court."
No,
That conversation?
I believe they initiated the conversation with me.
Yeah,
Did you
semantics.
say, "How are you doing?"
Something to that nature.
And did they respond? Something to the effect of, "I'm not doing so good because you attacked me and now I've got to defend myself in court."
I don't recall exactly what they said in response.
And then, based on that interaction, you arrested them for witness intimidation, correct?
Well, there was further interaction. It wasn't just the response to how are you doing? They made threats and they were ultimately arrested, yes.
So your claim now is that they made threats against you, a sitting police officer at the time, a working police officer.
Yes,
Okay. And you reported that threat to the DA's office,
yes,
and charges were brought against them. I'm sorry. A report was brought against them for that witness intimidation, correct?
correct.
Ultimately, with regard to the assault charges for which they were arrested and tried, they were found not guilty in a public adjudication, criminal case, correct?
That's right.
Correct.
And the DA's office threw out the witness intimidation charges because they were meritless. Isn't that right?
The charges were thrown out.
And all of this history that we've just talked about came on the heels of you assisting Chris and Tim Albert in a fight they said they had been in earlier in the evening. Is that right?
No,
You just told us that the reason you got involved in this melee, this fight to begin with, was because Chris Albert approached you and said, I was in a fight with some guys earlier tonight, and here they come.
yes, and you just said that he was with Tim Albert. I never saw Tim Albert that night.
My mistake. Let's just leave it at Chris.
He was with his fiance.
Okay. So all of this situation emanated from you coming to the aid of Chris Albert, your friend, longtime childhood friend, correct?
It had nothing to do with it being Chris Albert.
Isn't it true that it had everything to do with it being Chris Albert?
Of course
No.
it did.
So just a regular random guy off the street, you would have conducted yourself the exact same way.
Absolutely.
Isn't it true that what you actually did, Sergeant Lank, in that particular circumstance, was you came to the aid of a friend and you used your position as a police officer to further that assistance and that protection?
No.
That's all I have, Your Honor.
Okay, Mr. Lally?
Thank you.
Hmm. He was off duty, so, Clara Bell.
Whatever happened between Christopher Albert and these brothers in that particular evening, you weren't present for that?
No.
And your testimony that Tim Albert wasn't present at any point in time when you were there, correct?
No.
Now, with regard to Tim Albert, what, if any, other involvement have you had with him as far as through your official duties as a police officer?
I was involved in an investigation where we had to take out charges against Tim Albert.
So you've been involved in an investigation where charges were actually taken out against a member of the Albert family.
We had to take out charges against Tim Albert. You see how he said that? We had to take out charges. I really didn't want to, but we had to. So Lally's trying to prove that you don't always fix things for the Alberts, right? Because one time you had to take up charges for Tim Albert. Wow.
Correct?
Correct.
And do you recall roundabout when that was?
I believe it was 2012.
Do you recall who, if anyone, from your department was working with you on that investigation?
It would have been Officer Good at the time.
And that's now Sergeant Sean Good, is that correct?
That's correct.
Same Sean Good involved in this case, correct?
Correct.
Now, with regard to the federal suit that was brought, that was settled, correct?
That's correct.
There was no disposition on it, no finding of liability or anything of the like.
Correct.
Now, with respect to Brian, how would you describe your relationship with him?
Again, civil.
The two of you friends?
Could you repeat that, please?
Are the two of you friends?
No.
Do you socialize with Brian Albert, or have you at any point in time?
I've been at events where Brian is at, and we will say hello, but that's pretty much the extent of it.
Have you ever socialized with Brian Albert, just the two of you?
No.
You ever been to his house or inside his house?
No.
Now, with regard to, other than that day of January 29th, 2022, correct?
Correct.
You and Brian Albert, do you get along?
Say that again?
I said, he and Brian Albert, do they get along?
We have had some disagreements, I'd say, in the past, but we're civil. We get along enough to say hello.
Anything to do with your response, your interviews, or anything to do with January 29th, 2022, have anything to do with the Albert family or Brian Albert or Christopher Albert or anything to do with the Alberts whatsoever?
No.
That didn't change what you were doing, how you were doing it, or how you conducted yourself in this investigation. Is that correct?
That's correct.
Nothing further.
Okay.
I have one slight area to cover with the court's permission.
Okay.
Concerning Tim Albert and this issue, or the investigation where charges were brought against Tim Albert, that was a circumstance in which Tim Albert, in broad daylight, slammed into a parked car belonging to a woman and then fled the scene, correct?
No.
Oh, wait till you hear what Tim Albert did that they had to bring charges against him. Okay, listen. He's very, he doesn't like the semantics. He's gonna say, no, he didn't hit a parked car. He hit, a car. Listen to what Tim Albert did.
Did you follow a trail of transmission fluid or something to find where he had gone?
Yeah.
I did.
And he fled directly to 34 Fairview, correct?
What?
Correct.
He didn't live there. He went to his brother's house.
Mm-hmm.
Brian,
No, that's not correct.
he lived there at the time?
Yes.
Okay. So you follow the trail.
To 34 Fairview. What year did they say this was with Tim Albert? If you guys know, just put it in the chat. I don't want to rewind again.
Of whatever it is, fluid trail, all the way to where Tim Albert had fled to. And you basically had no choice. He had just slammed into the back of a car and then fled the scene. Isn't that right?
I concluded my investigation by locating the vehicle that had heavy damage.
Right, the vehicle that he hit.
His vehicle.
Oh,
His vehicle had heavy damage, but so did the vehicle that he hit, correct?
So what you had said a minute ago that he hit a parked car. That's incorrect.
Oh, he hit a moving car.
It was a vehicle that was, I believe it was stopped at a light. It wasn't a parked car. It was a vehicle that was stopped.
Okay.
really?
Irrespective of whether the engine was running or
2012,
not,
okay.
he hit a car.
So 2002, he bites a man, spits at Fredo in defense of Chris Albert. 2002, Canton PD, town of Canton gets sued. They have to pay a whopping settlement. I don't know exactly how much because of his behavior. Then they bring witness intimidation charges against the guy that he bit and spat at. Are you keeping track? And then 10 years later in 2012, he had to bring charges against Chris Albert. Because Tim Albert, another Albert brother, who slammed into a lady at a red light, fled the scene, and their excellent police work had them following the leak of transmission fluid all the way, like Hansel and Gretel's trail, to 34 Fairview.
Yes.
With a woman in it, fled the scene, then you find him trying to hide out at 34 Fairview, correct?
He had parked the car at 34 Fairview.
And you didn't have much choice. I mean, there you have it. The evidence is right in front of you. You can't really cover that one up, right?
I would say I did my job.
Your Honor, move to strike.
So this is Voir dear.
We don't need to object, Mrs.
Could you
Lally.
answer the question, please?
I would say I did my job.
Okay. Did you engage in any kind of a DUI investigation?
We spoke with him.
Did you give him FSTs?
I don't recall if I did. I know I didn't. I don't recall if Officer Good did.
Did you give him a breathalyzer?
That involved Officer Good as well, Sean Good, the one who shot home to his house, got the leaf blower, shot back to 34. Really? So that incident 10 years earlier involved also Sergeant Good? Oh, all right. See how you guys get promoted. These things happen every 10 years? Or just involving the Alberts every 10 years that we know about. 2002, Chris Albert. 2012, Tim Albert, and then 2022, Brian Albert. Oh, got it.
I did not.
Did you ask him for a blood test?
I did not.
So no DUI investigation was really undertaken, correct?
Again, I can't recall what Officer Good did. but I was there.
But you didn't do it. You didn't do what I just suggested, a full-blown DUI investigation,
No.
even though he hit another car and then fled the scene.
We spoke with him and he gave an explanation.
And that explanation coming from Tim Albert was, I'm really sorry, I panicked, right?
It was something to that nature.
And he turned around, well, I'll just cut to the chase. Y'all ended up charging him with a misdemeanor, correct?
I believe so.
And he was given diversion,
I don't know.
and his record was wiped clean.
I don't know.
That's all I have.
All right.
All right. You're all
Thank you,
set.
Sergeant. You can step down, sir.
You're all set.
I'll hear you, Mr. Jackson.
Thank you, Your Honor. I'll be very brief. I spoke about the Aguiar case a couple of days ago, and I think it's still attendant to our conversation today.
Okay, in case you're just joining, it's scrolling along the bottom of your screen, but we took a trip in time. We time traveled back to day 5 of the original trial, May 6, 2024. Sergeant Lank, voir dire, because the Commonwealth, this time Hank Breenan, has just made a motion to keep out not only internal affairs investigation reports and findings against the officers that were involved in the Karen Reed persecution, but also Lank, what happened 20 years ago with Lank in the civil suit. We just heard a whole bunch about what happened and his ties to the Albert family, and they're making this motion again. So I wanted to refresh many of your recollections who did watch the first trial, because your memory must be exhausted by now. And also, there are so many of you that I'm seeing in the chat who just can't even believe this, that apparently don't remember this from the first trial. We're not around. So this is what we're talking about. Close personal ties. And this is the argument for why this stuff should come in during the first trial.
Our discussion today, that case stands for the proposition that it doesn't matter if the evidence reveals something other than something that's otherwise inadmissible, as long as the material elaborates on or establishes that there could be some sort of bias or prejudice. There doesn't have to be a bias or prejudice. I don't have to prove beyond a reasonable doubt or to clear and convincing evidence that there's a bias or prejudice. But if the evidence suggests that there could be bias or prejudice, that is proper fodder for the jury to consider, and that's what we're asking. In this case, Sergeant Lank's willingness to activate himself as an officer, get involved with Chris Albert, although it was in 2002, and I know that that's something that Mr. Lowley's going to say, and he's going to harp on, this was so long ago, that actually cuts against the Commonwealth case. That shows how long these folks have been involved with each other and how deep their relationships run.
Right.
For him to sort of deputize himself in that situation in order to help out his longtime friend, whom he socializes with, drinks with, grew up with, establishes a bias and a prejudice, in this case against Miss Reed, and in favor of the Alberts. And it's not like he had a tangential part to play in this, a role to play in this investigation. He was the very first officer to walk in that front door.
He was the friendly.
Knew what he was going to find when he walked in the front door, which was the homeowners and possibly other witnesses. He engaged in a interview or a series of interviews that were not recorded. I have no idea what was said. The jurors are never going to find out exactly what was said other than to take his word for it. The jurors have to be able to weigh and balance his credibility against an officer that, for instance, even like Sergeant Good, for instance, who seems to come across far more unbiased, just sort of a straight shooter. Sergeant Lank is not that person. He never should have walked in that front door. He should have said to his supervisors, I have a relationship with the Albert family. I've known these folks for too long. I grew up with his brother or brothers. I've known them my whole life. I'm probably not the right person to make the decisions about this investigation. And unless and until the jurors know that and can weigh and balance it, they can toss it out if they want to, or they can adopt it if they want to. So if they need to be able to hear the evidence.
So I have a question for you. So the part about the complaint at the station,
Yes.
and being turned away. Who are you going to get that in from other than the Lopalito brothers, which puts us a little far afield? So he didn't adopt it or said, I don't know, or that's what I've heard.
So
He's a
the Lopalito
liar.
Brothers, I think.
I know, but that's so far removed now.
I disagree. I think they're the ones that are closest to the situation. So we would ask who's better to tell the jurors that they walked in. I can get the police report. I can tell the court what it's dated. It's dated September 2nd or September 3rd. And the Lopalitos walked in on August 31st to make the complaint.
No, I understand because you've outlined it, or Ms. Little outlined it, which is very helpful. I don't disagree that some of this is admissible. I just have to figure out how you intend to get it in, because I have to be concerned about if it's a mini trial within a trial, and we're trying to avoid that. If he were to testify.
No, what we're trying to avoid is a fair trial for Karen Reed, apparently. That's what we're trying to avoid. Because the Lopalito brothers were on the witness list for the defense, but you wouldn't let them in. And the whole point here is that all of these people have been colluding together for decades to keep themselves out of trouble, unless, you slam into a lady at a red light and then, the trail of transmission fluid at that hit and run leads right back to 34 Fairview where you park the car. But, nobody's going to breathalyze you or anything because you're an Albert boy. You're an Albert boy. This is 100% relevant. This is the guy who was the first one in the house, the only one they let in the house. The only one they let pass the foyer was Lank. He was the friendly. Brian Albert waited for him to let anybody in the house. And Jennifer McCabe called Lank at 9 a.m. and asked him to come back. Come back. I think I got to add something to my testimony. After, Julie came over with the birthday donuts and the birthday coffee that she was going to leave in Bry's car, even though it was freezing cold outside. And they were like, oh, come on in. We're having a family meeting. And then at 9 o'clock, she calls Lank, Jennifer McCabe does personally, to say, hey, can you come back? I got to add something to my statement. I got to add something. Oh, yeah. And when he gets back there, she says, oh, I forgot to tell you. And it was in front of a whole bunch of other officers. So I'm not sure if one of the officers wrote it down, but I forgot to tell you. So could you please add it to my statement? That Karen Reed said, did I hit him? Could I have hit him? Write that down. Write that down, Mikey. You always do what Uncle Bry says. But, we don't want to get into a mini trial here. Wow. This is May 6th, 2024.
As he did, that's what I understand. And the Commonwealth didn't object to that. That seems admissible to me.
Yeah, that's right. And then the next day, after she called him to come back to add that thing, the next day, she was in Michael Lang's driveway. Because, she was driving around with Kerry Roberts, even though they were never friends before, the day before. But she went with Kerry Roberts because Kerry Roberts had to either pick up or drop off a kid. We don't really know because she's changed her story a couple of times. And then it was found out through her location data by Richard Green, by the way, that she was in Lang's driveway. And because the defense had to turn over all of their impeachment evidence before the first trial, Tully prepped her on it, called her in to the DA's office. Tully, who's a law enforcement, by the way, not an attorney, and said, were you ever at Michael Lang's house? And at first she was like, no, I've never been there. I don't know what you're talking about. And then she was like, oh my gosh, I was. Oh, I remember. I was with Kerry Roberts and we had her daughter with, and her daughter is friends with Michael Lang's daughter. And then we dropped her off. But in her testimony, I think she said, in the statement, she said picked her up, but then on the stand, she said dropped her off. And then we were sitting in the car and, Kerry's a talker. And, so the wife, she's friends with the wife. And so the wife came out and talked to us and, we were, chatting. And so I remembered, I was in Lang's driveway the next day. Did you ever go in the house? Well, I don't know. No. Well, maybe I just ran into, use the ladies. Right? Yeah. Yeah. This is disgusting. This is corrupt. And this has been going on for decades. Okay. It has been. Welcome to the Hunger Games. Karen Reed is Katniss and she's fighting for her life.
I would probably seek to do it with the court's permission through two pieces of evidence. One would be Mark or Alfredo, and I don't think I would use both of them.
You would not.
I would not. Okay, fair enough. I would seek to ask Mark to join us, He would testify to the altercation, he would testify to the complaint, and then I would seek to either get a stipulation to the date of the police reports. I don't even need the police reports in. If I can't get a stipulation, then I probably would just ask the court to be able to establish that the police report is a business record.
So I would like to see those police reports tonight before I leave, okay?
If I have them.
We'd have to get them.
Right. I will do my best to get them to the court. I can't get them to the court tonight. We don't have them.
Okay,
So I'll start working on that immediately.
all right. Anything else?
No, Your Honor.
Okay, Mr. Lally?
And I would submit that defendant has him at his burn. There is no actual relevancy to any of this, and it is essentially a trial within a trial at this point. Bringing in other civilian witnesses to talk about an incident which happened 22 years ago to
So
involving.
let's forget about bringing in the civilian witnesses. How about what we heard as to what Sergeant Lank would testify to?
As to what Sergeant Lang would testify to is a single incident in which he did not witness anything to do with the Albert brothers. Christopher Albert was never at 34 Fairview Road on January 28th or until much, much later in the day of January 29th, and certainly not at the same time that Sergeant Lank was.
Well,
I think counsel.
You know what, Mr. Lally? Maybe you didn't read the original witness statements, because in the original witness statements, when Julie and Chris Albert were both interviewed together by I forget who, but they were interviewed together. They weren't separated. Of course, it wasn't recorded because they don't do that there. They do in every other case that we're looking at, like Brian Walsh and Harry Turk. They do record witness statements in most other in every other case except for this one. But here's the thing. In that original witness statement, I think it was taken by Proctor. It said Chris Albert and Julie Albert, after the waterfall, followed back to 34 Fairview. Anybody remember that? And then all of a sudden, what? Proctor lied? Yeah, didn't Julie Albert babysit for? No, it wasn't. It was for Proctor. I think that was Proctor, Kim, right? Was it Lank? I thought it was Proctor, that he had been talking to Julie Albert to babysit his kids, and that's when all that stuff about Courtney came out with the gift. Yeah, Olivia says they were interviewed by Yuri and Proctor. Yeah, but they did say, right, in that original statement of Chris and Julie Albert that they followed back to 34 Fairview, right? But now Lally is saying in open court they weren't there. Chris Albert's not relevant. He wasn't there, until much later. Okay, hang on. Chris Albert was never at 34 Fairview. Listen, and neither was Colin. Tell them the guy never went in the house. Colin Albert wasn't there.
Albert brothers. Christopher Albert was never at 34 Fairview Road on January 28th or until much, much later in the day of January 29th, and certainly not at the same time that Sergeant Lank was. Certainly I think counsel far overestimates what Sergeant Lank's involvement in this particular investigation was. He shows up on scene. He assists with the other officers, Lieutenant Gallagher and Sergeant Good, that you've already heard from. And with respect to, he takes a couple of initial statements, who all those witnesses then subsequently talk to troopers from the state police, testified grand jury, multiple grand juries, and will all be testifying as witnesses in this case. So any purported bias from an incident from 22 years ago involving a brother who wasn't even present at the home on the night in question does nothing but confuse the jury as to what the issues are. And
no, it gives them a sense of the close family ties and the sense of loyalty, the brotherhood, the code, the circle of trust, the fam. That's what it gives them a sense of. The 20-year Ray Donovan type situation.
Bias out of thin cloth that has no basis whatsoever in the facts of this case.
Okay, so I disagree with you. I don't know yet. I want to see those police reports. I don't know yet what I'm going to allow in, but I disagree that it has nothing to do. If it
quick, destroy the police reports from 22 years ago. Quick.
Weren't involving the Alberts, then under the grand jury case, the decision by Justice Gantz, Chief Justice Gantz at the time, it wouldn't come in, but it does. So it comes in for different purposes or different reasons. So I'd like those reports tonight or certainly by tomorrow morning before we come out.
We'll do our best.
Okay. All right. So we'll figure this out tomorrow morning. All right. Thank you very much.
Thank you, Your Honor.
Court, all rise, please.
And that's it. So that's the motion that they made again in this trial that we just went over to try and keep all of this stuff out. We have, if you want to, on your own time, go and watch day 6, which is when Lank actually testified. I haven't had a chance to rewatch it yet. It's going to give us maybe a little hint into how the judge is going to rule on this. And now we have the benefit of his testimony. So is it relevant? I think so. Is it more probative than prejudicial? I think so, because isn't this about Karen Reed getting a fair trial? Not about whether Lank has to get up and embarrass himself, right? Let's go to the chat. Chloe Albert's revenge. That's right, Mel. Own it. Like Legal Vices, when someone said he looked like the Lorax and he renamed himself the Lorax. Oh, that's awesome. Brilliant. Rest in peace. Legal Vices. Rest in peace. I never had the pleasure to meet him. I didn't know a lot about him, but those who lost him in the LawTube community and viewers, from all accounts, he was an amazing, amazing man. So very, very sad. Colin Alicia, I looked at ARCCA's website. They have a couple of crash mamas. Oh, look at you, David Reese, trying to widen the pond. Truth be told, can defense ask ARCCA how much they were paid by the agency that actually hired them for their opinions on? That doesn't come up, and that's an interesting question. I do not think that I don't think either side would want that in. Typically not, because they were hired by a third party, and so how would you get that information in? It would have to be authenticated. I would have to think about that. Nobody's asked. And I do not think so. Thank you. That's a great question. Paisley Chicken, I totally appreciate the snack break yesterday. I'm over 60 and I don't mind being in Melanie's kindergarten. Oh, is it fun? It's like the fountain of youth here. Thanks, Paisley Chicken, for your super chat. Captain Trips, buy the tickets. Life is short. Captain Trips is always a ticket. I met Jerry Garcia once in an elevator in the Hartford Hotel, and I was there, and we didn't have tickets to the show. And my girlfriend and I can't believe they let us on the elevator, but Jerry Garcia was in there with his bodyguard. And of course, my friend is a little Irish girl who's very loud. She's like, "Holy shit, Jerry Garcia!" And I'm like, "Oh my God, they're gonna kick us out of Andy. They're gonna kick us out of this elevator." And I can say that because she doesn't do any social media, so she will never see this. And we were like, "Jerry, we don't have tickets. We don't have tickets." And he had a really high, squeaky voice. It was like helium. He was like, "Girls, just go over to the side door over by gate, whatever. And eventually somebody will open the door and everyone just comes in. No worries. Don't pay the scalpers," he said. "Don't pay the scalpers." It was amazing. But yes, life is short. There's always a ticket and there's always a way. And this was so long ago. It was like before cell phone. I mean, this was a long time ago. Alessi's Google search knots. I took my daughter and 3 of her friends to see Spice Girls like 20 years ago. You're an amazing parent. Hold my halo. DUI guy gave you a shout out for being here every day fighting for Karen. I agree. Thank you for getting us through. When somebody told me that, but I didn't find the stream, or I don't know where that was. But I love Larry. Thank you for loving the kindergarten class. Allie, love Professor Melanie Little's class. Tons of snack stories, knowledge. The list goes on and on. Haters gonna hate. We got songs. We got lore. We got all of it. Thank you, Allie, for liking it. Greg, if you want another Disturbed coverage, check out their version of Sound of Silence. A lot of people have said that to me. I have not checked it out yet. Mike Dorado took his kid to see Weezer for her first concert last year. It was perfect. Everyone was pretty sober and nice. This was a first for a concert. Great. It's easier now that you can't smoke cigarettes anywhere. It used to be very, very smoky. I remember taking my kids. This happened to also be in Hartford, coincidentally, when they were little, to like whatever iteration of the Grateful Dead was out at the time. And we were sitting inside that Hartford Civic Center, maybe it was called at the time. I don't know. But the cigarette smoke, it was too much. It was too much. We had to leave. You're a great parent too. On top, thank you for your super sticker. Paralegal. Thank you so much. The fire captain who was murdered in California was my BFF. And Melon Cupcakes have been a helpful distraction for a broken heart. I'm so sorry. Justice for Captain. Does it say Marodi? I'm so sorry. I don't know. I wasn't watching the chat, but I'm so sorry for your loss. And thank you for your super chat. You loved it. You loved it. Thank you, Mama Shea. Garth, The Clash. I Fought the Law. Excellent choice. I Fought the Law. I'm going to have to come back later and rewatch the stream. Highway to Hell, I think, is already on there. Thank you, Dr. Russell as the GOAT, for tuning in from Norway. My Midnight Mike is here, and he gifted 5 memberships because he's amazing, and he's so generous always. Thank you, Mike. Love you with all of my heart. Girl from North Country, Bob Dylan. That's a great tune. You know, my kids have become now real Bob Dylan fans ever since Timothy Chalamet played him in the movie. So it's a whole new generation of Bob Dylan fans. Thank you so very much, Nina. Kylie, do we think Erin understands what Karen meant saying bad things about John and wish she never met an O'Keefe? Yeah, I do. I think so. I think a lot of times after you break up with somebody, you try and remember all of the bad times so that you don't miss them so much. That's the way I took it. And wishing she never met an O'Keefe. Yeah, I think there's been some speculation that the two of them bonded over, let's just say, dating, and one was married to, but dating two brothers who like to drink a lot, maybe. Thanks, Jojo, for becoming a member. Adriana B. First concert was Kid Rock, Lynyrd Skynyrd, and Tom Petty. I remember Lynyrd Skynyrd Pronounced was like, I think Shakedown Street was my first vinyl, but Lynyrd Skynyrd Pronounced was right up there. And those are the days. Chloe Alberts, thanks for super chat. Chloe Alberts Revenge, and don't forget Sergeant Lake Bites. We're behind in the chat, but we found, for those who didn't know, now know Sergeant Lake Bites. This nasty Greek votes. Can defendant ask notebooks get locked up every day in their presence and access log? Would she allow it? She's got wide discretion, as she likes to remind everybody. Might be a good idea. Would she allow that? I don't know. It's a good idea. Maybe they're watching. Again, Dr. Russell is a goat from Norway. Kesha, bastards. Don't let the bastards get you down. I have a Kesha song on there, Praying. I have Praying on there. That's a good one. Don't let the a-holes take you out. Don't let the mean girls take your crown. I love it. Kesha. Okay, all right, it's going. Dr. Russell's a goat. It's going on there. Can jurors take notes in a non-English language? That's an interesting question. And I don't know the answer to that. I'm sure if they know shorthand, they could take them in shorthand. It's supposed to be only for their personal use. So I would imagine if they know another language, absolutely, AK, I will allow that. Z said that he or she thinks that it was $3 million that the case settled for. The Lopalito case. I don't remember it being that much. If anybody has an actual confirmation on that, let me know. But I don't know. Bev's Overstamp is here. Did anyone get Lank's dental impressions? Right. A lot of people think that too. Maybe a forensic odontologist should come in for him. Can Josh Levy testify? Sorry, he says, I don't think so. Everything that he did during his time at the U.S. Attorney's Office would likely be privileged, and there would be nothing that wouldn't be privileged that he could testify to. A lot of the stuff's top secret. On top, Sergeant Lank. Sergeant Lank's call sign is Chloe. It might be. And Scott McGinnis points out that is now Lieutenant Lank because he got a promotion, right? As did DeChico and Kikowski, because, rookie move, should have had us do it. Strong-arming medical examiners to change the manner of death on death certificates for years. Of course he is, Sergeant. Of course he's Lieutenant Lank now. Laura Thompson, welcome. Auntie Debs, Officer Lank, do you know anything about the pig DNA found on John's clothing? Very funny. Thank you for that. Free Radical says, Chris Albert, DUI murderer of college student. Okay, I'm going to just correct the record. There were no DUI charges because by the time he turned himself in, there was never any DUI charges. But you are correct. There was a hit and run accident when Chris Albert was, I don't know how old, I think it was in the 90s. It was a fatality. An exchange student by the name of Peter Berger was killed in that accident. He fled the scene. He hid for, I don't know how long. I think it was like 30 hours. And then Judge Cannoni's brother, whose last name is Prescott, was his attorney. And yes, he was sentenced to 6 months in prison. For those who don't know. Now you know because Free Radical put a super chat in there to let us know. Chloe Albert's revenge. To be fair, he didn't activate himself as a police officer as much as a goon, but still bad though. All right. Thank you, Chloe Albert's revenge. And Josh, it's becoming clearer every day that Brennan was appointed as special prosecutor to serve as the Alberts defense attorney. Oh, yes. Oh, yes. Welcome. Welcome. Thank you. The freaking blue wall of the Alberts of Canton, says Sharon. Thank you. Mudwrecker, no one starts with this frame up. It starts smaller and builds as they get away with it. This calls into question the integrity of every case they've ever worked in their entire careers. My 2 cents only. Thank you, Mudwrecker, for clarifying and for quantifying and for your 2 cents. Bev's albuterol, we all appreciate you so much. Your passion for justice is infectious. Well, somebody's got to do it. Thanks, Bev's albuterol. Nina is back and is seriously concerned. I think they will do everything to get a conviction, including threat, bribe, or tamper the jury. I realized the obvious bias when Bev allowed Crosby right away. Karen Reed is in a world war. I know. Thank you, Nina. Diane became a member. Welcome. Colin Alessi, I took my daughter to her first concert, Evanescence, with Hailstorm. Oh, I love Evanescence too. I love that girl's voice. Camera Obscura, I swear, Bevs, you're all set. The state witnesses are so that you're all set. Can't wait for that to start again, eh? Not. Thank you for your super chat. Lily Rose says, I watch every stream, Melanie, and I love you for it. I love your legal explanations. Thank you so much, Melanie. Thank you so much, Lily Rose. That's a beautiful name, Lily Rose. Kelly says, the one with free Karen Reed and Stay Cool run really small. I got a 2X and it's more like a large, just an FYI. Well, there's all kinds of merch. There's like ladies versions and men's versions and unisex versions and oversized versions, and they all have size charts. So I'm sorry, I have no control over Spread Shop. It's a Spread Shop thing. Like I have nothing to do with it, except for I put up my designs and they sell it and ship it and all of that stuff. If it's too small and you want to exchange it for another size, I'm sure if you call them, they will accommodate. So thank you for letting us know. But if you need bigger sizes, you might want to order men's sizes or the unisex. Mickey says, I'm anxious for Melanie to read my email sent yesterday. A very smart woman and maybe can debunk my theory on losing sleep. Honey, I get hundreds of emails a day. I read them all. I do not respond to them all. I do not have time. I would need to hire someone to just respond to my emails. Do not lose sleep that I'm not responding to your email. Do not lose sleep over this case. You need to take care of yourself first and foremost. You can't imagine the kinds of emails I get every day, but your theory, I cannot write back to you to debunk your theory, to affirm your theory, because again, it is just a theory. If you would like to put some of your theory in the chat to share it with others, I'm sure maybe they will hear you out. You can put it in the comments afterwards and you can have others comment on your theory. And that might be a helpful way to help you sleep. But I cannot respond to emails because if I did, I would never have time to stream. Nikki ZBZ. Hank represented Whitey. One of Whitey's goons was Kevin Weeks. Yeah, Jen McCabe's maiden name is Weeks. I don't know if it's a coincidence or not. I have no way of knowing if they're related. I have no way. I do not in any way. I am not going to allow rumor, speculation, or anything else in the chat because I don't know. I just don't know, and I can't verify it, and that's why I'm based on facts and testimony and Paypizz and Paypizz. And Becky, thanks for the Venmo, says, I love that you're a Dave Matthews Band fan. And free Karen Reed. And yeah, there's two Dave Matthews Band posters behind me, and then the one in the middle is Dead and Company. So yeah, those are the two bands that I still follow around everywhere. Thank you so much, Becky, for your Venmo. And Mastad, yes, I will get all that stuff to you. Thank you, Melanie, for buying me a matcha latte. Says she loves listening to my breakdown of the law and my cheery voice. Oh, so many people don't think I'm cheery at all. Question, why is it that when the prosecution objects, they never explain what grounds they're objecting to? Only in this case, we need the judge in the Michelle Troconis case. Well, Michelle Troconis was in Connecticut. Every jurisdiction is different. They did we go over that motion where they want to state grounds for their objections, or is that one of the ones that we did not do yet? Did I do that earlier in the stream? My memory is so exhausted right now. But the defense does want to now be able to state the grounds for their objection in order to, and we don't have to go over the whole motion, I'll just tell you what it's about. The defense wants to be able to state the grounds for their objection, to just be able to get up and say, objection, hearsay, objection, leading, objection, foundation, objection, facts not in evidence, objection, speculation. They say that it's going to cut down on the time because every time there was an objection during the last trial, they had to go to sidebar. And a lot of the stuff was not recorded, right? I don't think we read the motion because originally it was in the court record as being the Commonwealth's motion, but really it's a defense motion. And the defense came out with a recent case in which it was decided by the highest court, the SJC in Massachusetts, that the record was not preserved because the attorney did not state the grounds for the objection on the record. And they're using that as their reasoning. So thank you for sending that by Venmo. If you do send, or that was buy me a coffee. That was the judge's rule. They're trying to get her to change it. I don't think I went over it. I really don't. But anyway, it's okay. Thank you so much for your buy me a coffee. I will, of course, read your questions and comments. Like Kimberly sent me a Venmo with a bunch of emojis. If you want to remain anonymous, just say anon, please. It's a great way to do super chats because for those of you who don't know, YouTube takes 30% of all super chats. Samantha says, silly question. Did any of the Commonwealth's motions require an affidavit? And if so, can the defense argue they're facially insufficient? Thanks. I think for the motions in limine, they might not be required. I don't know. I can't say I'm 100% familiar with Massachusetts rules. And I have heard some Massachusetts lawyers opine about this. And all of the law tubers who are out here from other jurisdictions are screaming that you have to have an affidavit of someone with knowledge in order to make any motion in any jurisdiction. Is this a special dispensation for Massachusetts attorneys? I don't know. But there was one motion that I remember of the prosecution that was denied by Canoni in this case because Liza Little got up and said, this motion is insufficient on its face because they did not attach an affidavit of someone with knowledge, and it was denied. And so that is a great question. I don't know if it also, I don't think motions in limine have to have them because they're just arguing what evidence should and should not be included or excluded. Yeah, special dispensation like from the Pope. So that's a great question. Make sure I got everything in here from people from today. And I believe that I did. And I believe that there's one more here. It's the false and irrelevant statements of Michael Proctor. Is that exciting? Is that anything exciting? Oh, they want to, well, you know what? We're here. So let's just do it because otherwise then tomorrow's a travel day for me. So please do not worry about me. I am fine. If you do not see me on the airwaves, it is because I am on an airplane. Please don't worry. People freak out. Like if you don't see me for like a day, don't worry. It'll be fine. If there's anything that's like crazy going on, you know, I'll find a way to do it. All right, let's just take a really quick look at this. This is 591, docket number 591. And this is the defense's motion in limine to exclude false and irrelevant statements of Michael Proctor. This is a cold read for me. I have not read this yet. They're asking the court to exclude any references at trial to false personal accusations made by Michael Proctor against Yannetti, including but not limited to Proctor's false allegations that Mr. Yannetti purportedly parked in the parking lot of a school in order to harass Trooper Proctor's sister, Courtney Proctor. Oh, yeah, remember that? I remember that. That was crazy. During the first trial of this matter, Trooper Proctor falsely claimed that when Mr. Yannetti had gone to the parking lot of a school where Courtney Proctor was allegedly employed, he, one, refused to leave the school parking lot when confronted by a teacher, and two, upon being confronted by a teacher, he asked about Courtney Proctor's whereabouts and asked whether she worked at the school. And that's from June 12th. Both assertions are false, as demonstrated by the police report of Canton police officer Eric Kaskovich, dated June 12th, 2024, attached here too as Exhibit A. First page of the report has been redacted to excise personal information of the involved parties, it says. See also the affidavit of David Yannetti in support of this motion. Okay. Yeah, I remember he said that. And it was like, he went there, didn't he go there to meet with Lucky? And he went, Yannetti went to meet Lucky to get his statement, right? In the parking lot, right? He didn't know that Courtney Proctor worked there. He wasn't going there to hurt Courtney, to like try and intimidate Courtney Proctor, right? Scott says, interesting, Glamasuso. Lanka was sued and the town of Canton paid his penalty. Well, yeah, they would, because he was employed by them at the time, even though he was off duty. They would be liable for his actions, not just the off, I mean, maybe not the off-duty part of the biting and the spitting, but for the charges that he brought against them, the false charges, like the witness intimidation charges and the stuff that happened at the mobile gas station. So Canton PD and the town of Canton would be what they call vicariously liable for his actions on the job. And I don't know where Suze's comment is, but it's a super chat. I just found a 2008 lawsuit against Lank, D. Giampietro, O'Brien, and Calorie. The plaintiff is John Armhine. Okay, I don't need any more homework, but maybe I'll get to it later. Thanks, Glamasuze. Let me try and finish this so that I can get out of here because I'm tired. Okay, so on June 10th, here's the factual background. Proctor testified as a witness for the Commonwealth on direct, testified about all those nasty text messages. And then he said, David Yannetti, I hate that man. I truly hate that man. On redirect, Trooper Proctor was asked to clarify why he disliked Mr. Yannetti. During his response, Trooper Proctor falsely claimed that Mr. Yannetti had gone to the parking lot of a school where Trooper Proctor's sister worked the day before in order to harass her. Really? Yeah, remember the judge said before the first trial that none of the witnesses will be able to talk about the harassment that they've endured unless they bring it up organically. You know how many brought it up organically? A lot. A lot. Jennifer McCabe, Allie McCabe, Colin Albert, a lot of them. Trooper Proctor falsely claimed, apparently referencing rank and false hearsay, as Trooper Proctor did not claim to have been present when Mr. Yannetti was there, that Mr. Yannetti had been asked to leave the parking lot but refused. Wow. A lot of perjury going on there, huh? Think maybe some of this is what he's being tried for in front of the MSP trial board? I don't know. Proctor also falsely alleged that Mr. Yannetti asked someone at the school if Michael Proctor's sister was working there that day. Oh, wow. He testified that Courtney thought she was being served, although there was no evidence that Courtney Proctor ever saw Mr. Yannetti that day. At this point in the testimony, defense counsel objected and the court requested that the counsel approach at sidebar. After consulting with counsel, the court correctly concluded that Trooper Proctor's testimony regarding Mr. Yannetti should be stricken from the record and instructed the jury to disregard the testimony. Yeah, like that helps. Like that helps. After the trial ended in a mistrial, defense counsel received a copy of a Canton Police Department incident report that was filed in relation to Mr. Yannetti's presence in the school parking lot on June 11th of 2020. You can't make this up. You just can't make this up. The mistrial was declared on July 1st. So after the trial ended, then they're getting a copy of this police report that was filed on June 11th, 2024, footnote 2. Notably, the report was not provided to the defense during trial, when the defense could have used that information to further impeach Trooper Proctor's credibility. Well, there's another reason why. Why should the defense have to turn over their impeachment evidence if the Commonwealth didn't? You can't unring that bell. That's right. And Courtney is Proctor's sister. Please get the facts straight. Did I not say that it was his sister? Who's not getting the facts straight? Elizabeth Proctor is the wife. Courtney Proctor is the sister. You talking to me, Paula? You're probably not, because I don't think I even said if it was his sister or his wife. I'm just reading the damn document. What's good for the goose, right? What's good for the goose? If the defense should have to give over their smoking guns, why shouldn't the Commonwealth have to give over their smoking guns? Especially since they prepped Proctor. They prepped him. They knew about this. So, hello. How come you're not giving us anything? This should be a reason why they should not have to turn over their impeachment evidence, because they didn't do it. Now we got to make this motion? This just makes me mad. This just makes me mad. The incident report directly contradicts every false allegation from Trooper Proctor's testimony on June 12th, 2024, and shows that Trooper Proctor made completely false statements under oath. Wow. Wow. That's going to be some great fodder for cross-examination or direct examination if they have to call him in their case in chief, because, you think Hanky, Panky, Spanky is going to call him? No. The incident report states that the principal of JFK Elementary School contacted Patrolman Eric Kaskovich, school resource officer, to make him aware that Mr. Yannetti and Brian Loughran, also known as Lucky Loughran, the plow driver, had been seen in the school parking lot that day. The principal informed, you know what I want to know? Who was following David Yannetti around? Were there maybe some not so confidential informants following David Yannetti around? Oh, inquiring minds. Do you think anybody that worked at that school would have any idea who David Yannetti is? Do you think anybody inside that school would know who Lucky Loughran is? Because Lucky Loughran wasn't called until the defense case in chief. This is during the Commonwealth case in chief, right? Huh. Who was following David Yannetti around? I want to know. The principal of JFK Elementary School called the school resource officer to make him aware that Mr. Yannetti and Brian Loughran had been seen in the parking lot that day. Not that they were there. They'd been seen that day. Somebody called the principal. Yeah, Free Radicals like, I think you're right. Somebody was following Yannetti. Has this ever been brought up before? I mean, I'm riffing here. Just came to me. This like a stream of consciousness. Oh, that's what I should call my streams. This is like a stream of consciousness. Huh. The principal informed Patrolman Kaskovich that Miss Yannetti and Mr. Loughran were not approaching the school, students or staff, and that she only wanted to make Patrolman K, we'll call him, aware in the event that things escalated or hit social media. Oh, really? They're worried about social media now? The principal's worried about social media? Sam says, yeah, there's a picture someone took from inside the school of Miss Yannetti and the PI and Lucky. Oh, probably a soccer mom we know. Okay. Someone who knew her story. I don't know. In the event things escalated or hit social media, and that's in the police report. He detailed that it was reported that neither individual ever approached the school, students, or staff members. Patrolman K observed Mr. Yannetti, Mr. Loughran, and two individuals pull into the parking lot, talk for 5 to 10 minutes, and leave the parking lot in their separate cars. So Patrolman K says that he saw that. Hold on. That he observed Yannetti. All right. Patrolman K wrote that none of the four ever pointed at or approached the school, staff, or students. Trooper Proctor claims that Mr. Yannetti was asked to leave, refused to leave, and inquired about Courtney Proctor. Were all completely fabricated during his sworn testimony. Oh, Mr. Proctor, was it worth it? Was it worth it? Was it worth it? Trooper Proctor should be disallowed from making these type of inflammatory accusations against Mr. Yannetti and Ms. Reed's retrial. Any evidence related to Mr. Yannetti's presence in the school parking lot must be excluded, along with all false accusations that Mr. Yannetti harassed or intimidated Courtney Proctor or other members of the Proctor family. Trooper Proctor's previous testimony and any statements regarding Mr. Yannetti's presence in the parking lot are completely irrelevant to the issues presented at trial, and there's no probative value to the fact that Mr. Yannetti appeared in a parking lot to permissibly and appropriately prepare a witness to testify as set forth here, and this evidence must be excluded. Yeah, and also, maybe Trooper, or soon-to-be ex-trooper, former trooper, Pooper, Proctor should be indicted on perjury charges. Maybe that should happen. Because perjury is really a crime. Ask Kayla Montgomery in New Hampshire. Remember Kayla Montgomery? The wife of Adam Montgomery, who was a party to the disposal of Harmony Montgomery. Yeah, she went to jail for perjury, for lying to a grand jury. Did some time, maybe a year or two. And then they go on to say that these things all have to be excluded because they're lacking probative value and therefore is inadmissible. And they go on and like, I'm 100% on board with this. So I'll scroll through this. Lies, lies, lies. Yeah, we have an emoji for that. Lies, lies, lies. The Thompson twins. That is also. It is also in the playlist. Thompson twin lies. Just like this part. Given Trooper Proctor's lack of firsthand knowledge regarding a false allegation that he purposely and recklessly tried to put in front of the jury, there are only 3 explanations for his testimony. 1, someone lied to him about what occurred in the parking lot on June 11th, 2024. And he testified to it without doing any further investigation to find out. I lost my place. To find out if it was true. 2, Trooper Proctor somehow misunderstood what was being told to him and never sought to clarify that the information was before testifying to it under oath. Or 3, Trooper Proctor blatantly lied about what occurred in a desperate attempt to take attention away from his egregious conduct in conducting and manipulating this investigation to get the result he sought. Justice be damned, yeah. We're all. There are only 3 explanations. All of the above. That's a great soundbite, right? The defense has its suspicions about which explanation makes the most sense, but whatever the reason, his testimony was false, misleading, and speaks poorly of Trooper Proctor's ethics. I'm sorry, what? Trooper Proctor has no ethics. Trooper Proctor's ethics and investigatory skills, yeah. If allowed to testify at the retrial about this fictitious interpretation of what occurred in that parking lot on June 11th, 2024, there would arise a significant danger that admission of the evidence would unfairly prejudice Ms. Reed. Well, yeah. Would also confuse the issues in this case. And the presence of one of Ms. Reed's attorneys in a parking lot of a school in order to do his job as a lawyer, i.e. to prepare a witness to testify, is not at issue in this trial. All right, we got breaking news. Again, we don't think that should be allowed. We don't think it should be allowed, but Judge Canoni has ruled on one of the motions, my friends. Thank you so much for sending this to me, girl, because if you want to get mad, ready, get the Tums out, people. Get your Tums out. I'm going to go into the docket so I can pull up some more things for you, but she has ruled, maybe just now, that defendant's motion in limine to exclude witnesses' prior criminal history has been allowed. Oh, no, that's good for the defense. Wait, no, to exclude? Defendant's motion in limine to exclude witnesses' prior criminal history is allowed. Wait a second, 574. What motion is that? Hold on. Let's go to 574 so we can refresh our recollection. There's way too many filings in this case. She's allowing a defense motion? Hold on, I'm shocked. I'm in shock and horror. I have to pull it up to see what it's about. 574. Why are you not coming up? 574. Hold on. Do I not have 574? I thought everything was in here under numbers. The numbers. All right, what's it called? Defendant's motion. Eliminate to exclude witnesses' prior criminal history. Can somebody, was ruled on yesterday? No biggie. Oh, Richard Green. That's what it was. Richard Green. That is confusing. Yes, Richard Green. Okay. Right. Because the Twidiots dug up. Yeah, the Twidiots dug up an old bar fight that maybe expert witness Richard Green was involved in. And they posted his mugshot all over Twitter. And I think it was impounded. Thank you. Oh my gosh, thank you. I'm not crazy. I'm not crazy, but really I am crazy. I am crazy. I am crazy. So that has to do with the Commonwealth wanting to bring up the fact that perhaps at one point Richard Green was involved in a bar fight. Richard Green is the cell phone expert, forensic cell phone expert for the defense. This happened when his dad was dying. It was a bar fight when his dad was dying. Yeah. The Twidiots found it. The not so confidential informant might have blasted it out there. Richard Green. I know. We're not crazy. I got scared for a minute too. I saw it because the second I saw allowed, I was like, oh, here we go. I could never imagine that she would, allow an actual defense motion. So I was very confused. She agreed with the defense. There's one, you guys. Ding, 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 ding. It was a dismissed disorderly conduct. Yeah. He was drunk, I think, allegedly in a bar, and it was dismissed. So thank you, guys, for pointing it out. I think it was impounded, and that's probably why I don't have it. Yeah, isn't that shocking? Isn't it shocking? It is shocking when we get something that goes our way. Hold on a second here. Let me just dig deep. Let me just dig deep into the nether regions of the court docket for a second and see if there's anything else that they just put a little allowed next to. You're saying that was allowed yesterday? All right, let's see. See if there's anything else. It was dismissed. You couldn't let it in anyway. Yeah, but this is why motions in limine are important, because we got to head this stuff off the pass, you know? We got to put a stop to it before the shenanigans even start. And this was allowed without any opposition from the defense. I mean, but the defense, the Commonwealth being heard, without any argument being heard. It was just rubber stamped in favor of the defense. I'm shocked. I'm in shock and horror. So that's good. Is there anything else here that was allowed? The motion to impound the motion in limine to exclude irrelevant admissible prejudicial evidence with regarding harassment of witnesses, that was allowed. The motion to impound that was allowed. So that was impounded. That's docket number 570. I don't think there's anything else. Yeah, the defendant's motion in limine to exclude witnesses' prior criminal history, 574, was impounded. Great. We're getting somewhere. We're cooking with gas. And then apparently this is allowed. So what is that? Docket number? It's allowed, though, that it was impounded, or it's allowed that they're not allowed to let it in? Because now I'm confused, because this is underneath 574. And when I go in the docket right now and I look at 574, it says impounded. It doesn't say allowed for me. So the motion to impound that was allowed. I'm going to refresh this, but I don't want to put the wrong information out there, although this is a screenshot that was just sent to me. So I don't really know. I don't really know now. And now I'm afraid to be wrong. Because when I look right now, I'm in the docket right now under 574. It may be because I have cookies in here. I don't know. It says impounded. It does not say allowed. For me, it says impounded. So I don't know. I don't know. Look at 568. Hold on. Yeah, that's a motion to impound the defendant's motion. It says allowed. So it was allowed. The allowing is the impounding. They're allowing it to be impounded, Suze. So that was a motion to impound. The motion to impound was allowed. And that's 597 is another motion to impound. Those are just motion to impounds that are being allowed. So let's not get in the weeds here. And now that I look at the court docket myself, I don't know if this is accurate. I mean, I trust you sent it to me, but let's just get that off the screen. And I just have to, until I see it with my own eyes. Yeah, impounded means sealed. It just means sealed. It's a fancy way of saying sealed. In New York, that's what we would say for impounding your car when you have too many parking tickets. Badass Bianch says off topic, but I'm hoping you will go. You will be covering the Idaho trial. Yeah, that's not happening until August. You know what? Maybe we'll go into that as jurors, and go into that. Not getting into all of the motions and all the pretrial stuff, but yeah, I'd like to cover that. Sure. Karen Reed's trial should be over by then. Isabel Park, I remember the beginning of the trial and what it has turned into now. How many more lies can the Commonwealth tell? All of them, Isabel. They can tell all of them. Thank you for your super chat. Lara Knockcroft, I don't know any grown men or even young men that have gotten into any physical altercations. Does anyone else think it's alarming that so many siblings from the same family have? Welcome to Canton, babe. Welcome to Canton. Thanks for the super chat. Here from the beginning, says Pierre. You're still the best. 15 months. Wow, you are an OG, Pierre. I know you are. Nina, haha, if I was a juror, I would write my notes in Swiss German and draw hearts around Jen's name just to mislead Fanning. No tampering. LOL. XOXO. Oh, that's great. That's fantastic. Love it. Adam Lally's resignation. You changed your name back, Bo? Safe travels. Thanks for so much for always being here for us. Love you. It is Bo. Bo changed her name back. No, Adam Lally has not resigned, but Bo had to change that during the Brian Camp trial because everyone was so confused. They were like, did Adam Lally resign? Thanks, Bo. And thanks, Bo, for being the ground during the Brian Camp trial. That was pretty awesome. Paula, wasn't anything regarding what Melanie said. Oh, thank you, Paula. Thank you, Paula. I'm off the hook. Pam says, thank you, Melanie. Thank you, Pam. Free super chat. Mike, it's really interesting you bringing up your travel. I know we shouldn't worry, but the way they went after you worries us. Have a safe trip, dear. Thank you. Thank you very much. I will check in with you. I always have my equipment with me. I always travel with my stuff because, it is only when I travel, because I am a very busy mother of 5, that it is only when I travel that things really seem to break. And so my kids know, and everybody knows that, mommy's got to work. So it is what it is. Thank you so much. Madam Roz, Traub email copied Rafferty, but Canton PD was conflicted out. Great point. That's a great point. They were conflicted out on January 29th, 2022. But, let's keep Chief Rafferty in the loop. He lied out of whole cloth, said Yannetti. Yes, he did. Yes, he did. He said that. That's the thing. It's not an expression that I ever use, but I have heard a lot of lawyers use it, and it's not something that ever stuck with me. It's strange credulity that stuck with me. He lied out of whole cloth. I don't know, making it up out of whole cloth. It's something I've never been on board with, but I'll allow it here. Jason, hi, Jason. Lank was off duty, but activated himself in that incident with the brothers. Canton paid out $300,000. Thank you. Somebody said $3 million. I think you are correct. I think it was $300,000 for his involvement. Yeah. Yeah. So Lank's actions cost Canton a lot of money. Hazel's mom became a member. Good, welcome. And hello to Hazel. Hey, Hazel. Love that name. Love that name. All right. We're going to leave it here for now. Don't worry about me tomorrow. If something crazy happens, I will find a way to contact all of you. So don't worry about me. Olivia says, I think it's a subtle dig at Michael Morrissey because in his letters to the feds, he accused the defense of making up their theory out of whole cloth. That's right. That's why I used it at least. Yes. Yes. But a lot of attorneys use that phrase, that turn of phrase often, right? They do. It just never rang true for me. All right. Thank you to the moderators. Because again, this was another marathon today, 3.5 hours. You guys are here. You're with me for every minute of it. And I love you. I couldn't love you any more than I already do. Stay safe out there. Stay cool, stay kind, stay classy. Do all of the things that YouTube likes. Hit the like, hit the subscribe. It's free. Hit the bell so you get all notifications because sometimes when I go live, it's just like, I'm live right now. Like when I was at the Dave Matthews shows in Cancun and you guys were there with me and we watched Dave sing some really nice songs 3 nights in a row. And it was really fun. We did that together. So many of you actually were with me in Cancun, kind of. So there was that. All right. Stay cool, stay kind, stay classy, and stay safe. Stay calm. Oh, look at my chapped lips. Got to get the Nivea. Peace.